Your Lordship, kind permission. Fresh matter for admission for contempt proceedings, my lord.
It will be posted why or
Any other day, though the
any day, then it will go to 17th March.
please, my lord.
Lordship's kind bill. Before the vacation, my lords would remember regarding the economically weaker section land which belongs to the corporation which is illegally mortgaged. My lords, on the last day before vacation.
As such, we don't remember any matter which are,
I'm sorry, my lord. In that case,
except those which are on board today.
okay. In 1986, my lord, Bbmp allotted apartments to 1,512 economically weaker section for consideration, apartment for consideration of 35,000. The apartments were built. In 1996, 2 blocks fell down and all entire 1,512 families were evacuated. Thereafter, writ petitions were filed to see that the Bbmp reconstructs the apartments, which never happened despite an order passed by this honorable court in 2010. And subsequently in 2012, we discovered Bbmp had entered into a public-private partnership with a third-party developer when only 1/3 of the land was supposed to be developed and given for the weaker section, and the rest of the land is to be given for commercial development. Though there's a finding by this honorable court that land belongs to 1,512 economically weaker section. And then we went for this honorable court, we suggested that because Bbmp did not have funds, let there be a sort of compromise. So 50% of the land was supposed to be
What
developed.
do you want?
My lord, the land has been mortgaged and has been, they come out with a section 13 notification. And now they moved the honorable magistrate under section 14 for taking forcible possession, my lord. This matter was argued on quite a couple of occasions before the vacation, my lord, and Bbmp said they'll take instruction. There's also Lokayukta finding that the mortgage.
What is the request?
My lord, may be listed tomorrow because we are pressing for a stay.
Tomorrow, not.
Any short date, my lord.
When it is kept?
They are,
When it is kept? Some date must have been given.
no date was given, my lord. It was supposed to come immediately out of vacation.
Can't happen as far as this court is concerned.
Kindly, my lord gave me the liberty to move the honorable vacation judge in the event there is a notification for auction. That notification did not happen.
No, it can't happen in this court that no date is given in any matter.
My lord, I'm making a submission because liberty was given, my lord, to move the vacation bench. That is the reason.
If the date is not given in any matter in this court, then the
I'm
officer
sorry,
will take- will take a
correcting
difference.
if I
You have to ensure that each matter which is adjourned should not go without any date, as far as this court is concerned.
My lord, the observation was to move I wanted immediately after the
To
vacation.
find out about this, whether date is given or not. Then mention, yes.
So with permission, Lordship, item number 62,
Item number
62, contempt, they have complied, will not survive for consideration.
52. Learned
62.
Mr. Anu,
Filing the memo to that effect. Your Lordship.
you are for?
I am for the complainant.
Learned Advocate Mr. Sonjo, for the complaint stated by filing memo dated 22 to 2025 that the complainant wants to withdraw the contempt petition as it is being infectious in view of the compliance ordered in it 21/6/23 passed in the writ petition number 15794. Full stop. The memo is taken on record. The petition is dismissed as not surviving.
Obliged.
My lords, this is a fresh matter, my lords. The office objections are complied.
Which one?
A fresh matter. It has not been posted before this honorable court even for once. I request your lordship to kindly have it on Friday, my lords.
No.
Or any day your lord pleases.
No. If date is given, then file IA.
Fresh matter, my lords. It has not come before this honorable court.
Fresh matter.
Yes.
What is the urgency?
My lords, the honorable governor was pleased to pardon 2 of the appellants in this matter, my lords. And the victim of this case had approached the honorable, the single bench for cancellation of pardon. The learned judge was pleased to cancel the pardon granted by the honorable governor.
19th.
My lord,
19th.
much obliged, my lord.
Give my lord. On 18/12, this matter was heard, man. That time Bbmp counsel wanted 2 weeks time to file objection. And the learned government advocate also said, we'll verify. The matter is urgent because third-party rights will be created.
That is all right.
I'd also filed the Lokayukta report where there is a finding that the entire mortgage is illegal also.
So the court officer will verify whether a date is given or not, mention at 2:30.
At 2:30.
My lords,
Just verify the date is.
my lords, petitioner was a library supervisor.
Pardon?
Petitioner was a library supervisor. He has a threat of termination from his post. In the other identical matter, the notice has been issued by this honorable court, hence any date may be
27th of February,
27th
27th.
February.
Writ appeal matter, my lord. I am for the respondent 5, my lord.
Yes,
So the order is in our favor.
which matter?
Sir, writ appeal, my lord.
Which one? It is posted today,
No, my lord.
fresh matter, new matter.
So in the last date, the opposite counsel without informing us taken the date and it kept for March 20, my lord. So construction is going on, order is against them. The matter is for 37 years, matter is, my lord. Intentionally, they are making delay, my lord. So by this matter, please have it on next week, 2:30.
If date is given by judicial order, no preponement by oral request. File interim application showing the urgency for preponement.
The matter pertains to a PI filed in 2021 regarding the railway tracks within the Western Ghats and its impact on wildlife. It will be taken up urgently. It's been pending for.
What you are doing for 4 years?
we've been-
What you are doing for 4 years? It has never come up before the court.
No, it has come up. It's a pending matter. It has come up multiple.
Then file IA for preponement. Date must be given.
My lords, serial number 29, my lords.
20?
Request 29, my lords.
Yes.
Appearing for the petitioner, my. My lords, requesting for 3 weeks' time, my lords.
Why?
My lords, my senior will be out of station.
Extend over to 7th April in view of the request made by learned review the appel petitioner that learned senior counsel who is to conduct the petition is not available for personal reasons.
Great, my.
Serial number 17, my lords, list
17,
1. IPF the appeal, kindly pray for 2 weeks, my lords.
17, 2 weeks. It will go to 26th March as requested.
Great.
Serial number 40, serial number 40, my lord. Serial number 40,
Five,
40, my lord.
40.
40. Senior is not keeping well, my lord. Kindly have it on next week. my lord.
One second. That is contempt petition 872,
Yes, my lord.
872.
Yes, my lord.
What do you want?
Senior is not keeping well, my lord. Kindly have it on next week. Anyone?
3rd April.
My lord, I am filing early hearing application, please. It's a medical reimbursement case which was unpaid from past 1 year. It has not reached. As such, I am filing early hearing application.
What is filed? What is filed?
145/2024.
You file interim application if the date is given.
Please.
Is an interim application?
Please.
All for preponement.
For early hearing.
Application is filed.
Yes.
All right. Let us list it on 17th.
17th. 7th it is there, please. Next month it is there. This month it may be taken up.
Pardon?
It may be taken up by this month,
First,
please.
the application for preponement will be taken up on that date will be given for the main matter. So this application will be posted on 17th. Not the main petition, right?
Any other mention through VC, sir?
Forty-eight. Rate appeal 1340/2021. Not to be placed before the bench where one of us will get Honorable Mr. Justice. Am I wrong? Beggar too, or is a member? All matters common order up to 48.2.
Confirmation, the contempt matter, seal number 1. Srimati Navya Shri R. Rao, 14%. Seal number 1, Srimati Navya Shri R. Rao, 13%.
Not there. Pass away.
Number 2. Mr. Balakrishna.
I appear for the complainant matter. It's a cooperative society matter. One of the member of the complainant society had filed a complaint in the year 2019, my lord, against which the second respondent had passed an order to conduct an inquiry. An inquiry officer was appointed, and he went to the society and he has given his report stating that out of 6 allegations which were made against the society, 5 of them were not proved as per the complaint. And one charge was that an employee was working there as an executive officer. He was continued his service even after attaining superannuation, my lord. So he was to retire on June 2015, but 1 year was extended from July 2015 to 2016 May, my lord. And regarding this, my lord, the second respondent has stated that after retirement, no person should be employed because of the superannuation. Don't entertain against the interim order. The order which is subject matter of this contempt petition is order dated 28/8/24, passed by Learned Single Judge in the pending proceedings of writ petition number 13973 of 2024. Learned additional government advocate, Mr. Sujay appearing, appears upon service of copy of the petition in advance, is justified in highlighting the said aspect that the order is an interim order. Learned advocate for the petitioner, Mr. So-and-so also could not dispute the factum of the order being interim in nature. Paragraph. When the order is interim order, evidently no rights of any of the parties are finally crystallized. Full stop. Not only that, the proceedings are stayed by Learned Single Judge as interim measure. Proceedings pursuant to Annexer K dated 11/3/24 are stayed by Learned Single Judge as an interim arrangement till the next date of listing of the petition. Even the statement of objections is yet to be filed. Full stop. The Learned Single Judge is seized with the subject matter, including the continuance or otherwise of the interim order, which shall be done in accordance with law. Full stop. No case is made out to interfere in the contempt jurisdiction at this stage. The parties are at liberty to work out their right and remedy before Learned Single Judge in the proceedings which are pending at large on merits. The present contempt petition is dismissed on the said ground alone. Said ground only.
Number 3.
इसकी
Rashid
I appeal for
DJ.
the complaint counsel. The petitioner, there is a delay of 176 days. May Lakshmi kindly appreciate my land was to an extent of 2 acres 36 gunta was utilized for the acquisition for Naraprabhu Kempegoda layout. So Lakshmi kindly consent award is passed on 24/5/2022.
Yes.
Lords, I'll take notice for first
We
response.
are not going to issue notice.
Lords, the competent authorities respondent number 2 and 3, my lord. BDA minutes.
Maybe. Yes, when did you serve the copy of this order to the others?
The order is, may I request my page 12 kindly be.
When did you serve the page 12 order on the
12,
other
you-
side?
yes, sir. So Lakshmi kindly, the partial complaints is, your Lakshmi, I request my lord to
We
the,
are asking that when did you serve the copy of the page 12 order on the other side?
I served on the 4/12/2023 representation.
4/12.
Last representation, 4/12/2023, my lord.
We are again asking This is the last time we'll be asking.
Honorable Division Bench order is on 16/1/2023.
We are last time asking. If you are able to answer, answer, then we will proceed with the.
January, we are given the January 2023, given the representation.
We are asking that the order dated 16th January 23, figuring at page 12, which is subject matter of contempt, was served on the other side on which date?
Yes, that is served, Your Lordship, kindly legal notice is issued on why, Your Lordship, may I request, my Lord, you kindly just read the operative portion of the Division Bench of this court.
Again, you are not answering.
In January 16/1/2023, given a representation. Last representation is on 3/10/2024. The provisions of the section 20 of the Contempt Court Act, limitation for action for contempt. No court shall initiate any proceedings of contempt either on its own motion or otherwise after expiry of the period of 1 year from the date on which the contempt is alleged to have been committed. May I request, my Lord, here, the partially, there is a compliance of the order of 27,791 square feet is by virtue of the consent award is given. Later, my Lord, the remaining an extent of 12,870 to be partially compliance is there.
Where is that?
Partial compliance is there.
Where is,
Now remaining 12,872 is to be given.
where is that partial compliance?
That is that extracted in my contempt petition itself. May I request, my Lord, page 8 of my contempt petition. Kindly see, my Lord. The last complaints execution is 4/8/2024. I narrated in my petition para 7 of my contempt.
What is partial compliance?
Totally, they are given 27,791 square feet instead of.
VDA was to consider the application for grant of incentive sites
Yes,
in 40/60 scheme.
yes.
So how many petitioners were there? Only,
One petition.
only one petition.
Yes. Total extent to the land was utilized
So you were to given some incentive.
27,791. The consent award is to an extent of how much? Total extent. Total is 27,791, out of which only 14,919 given. That's why I am the land loser. Kindly appreciate, my Lord.
This time bar.
Please.
Time of essence. But did you took any action pursuant to this order? You find out. If you have taken some action and it is halfway, then we'll say that it is within time.
That's BDA has to take the action, my lords. It is the BDA.
You copy to the council for BD.
Yes. I may permit it to serve on the council of the.
No notice. It doesn't book notice, this petition.
Oblige.
Only you are assisting you. Prima facie it is time bar. Put up on 6th of March. We open for the council, the petitioner. I requested by him to serve a copy of the Governor Advocate who normally appears on behalf of the Bangalore Development Authority in this court.
Cell number 4, HR Santosh.
Serial number 456 arising out of the common order. The order was on 11/9. We have served it to the respondents on 7/10. Page 61, the direction number 2 has to be complied.
So you are permitted to continue the utilization of sewing
Yes, my lord.
contrivance covered under the license.
Yes. The amended act, my lord, was held to be prospective. Whatever the number of sawing contrivances as on that day will have to be continued now by issuing a fresh order. That's the direction.
Time limit is not stipulated in petition.
No, we are trying to understand what is permitted.
The respondents are hereby directed to permit the petitioner to continue the utilization of sawing contrivance covered under the license, which are existing prior to 20th of May 2013. That is an amendment made by the state government and renewed subsequently strictly in accordance with terms and conditions of license. This is a case of renewal of a license. They applied the amended act and they said fresh license cannot be given. Addition to the additional sign contrivance cannot be added. This court held it is prospective.
If the new regulations or rules have come into force, then it will govern.
No, my lord, the judgment of the Supreme Court so far as sign contrivance. 30th of September 2002, whoever has got the sign contrivance, that will continue. Now the state government has brought out an amendment, subject to the feasibility of violating the hood, the addition contraventions would be added. That is only prospective.
You find out there is a question of time limit here.
There is no time limit.
It is to be permitted, then if some new amendment has come into force, this will be wiped out. And the petition cannot take advantage of this direction. Find out.
I'll take instruction.
Notice written alone. 24th, 28th of February.
5 and
4, 5, 6, my lord, all common.
All same? All same.
Yes, common. This is number 7. Noor Ahmad.
My lord, the petitioner was applied for compassionate appointment, my lord. The honorable tribunal has been rejected my application for compassionate appointment. Again, I challenged as per the page number 10, my lord. I challenged the order before the Honorable High Court. Operative portion of the order, my lord, in ink page number 13, my lord.
Yes.
Ink page number 13, my lord. The writ petition is allowed. The order of tribunal dated 13/4/2023 is in application number 1044 of 2022 is set aside. Annexure E endorsement which is impugned before the tribunal shall stand set aside. The competent authority shall consider the application of the petitioner for compassionate appointment in accordance with the rules and force without raising the objection that she is a married daughter. My lord, the respondent number 2 again issued the endorsement on the similar ground, my lord. Ink page number 32 is the operative portion of the endorsement, my lord.
It is considered.
My lord, may kindly see the ink page number 32. Again, the authority has been raised the objection, very similar objection, my lord. 32 operative portion, my lord. It is a typed copy, translated copy of the endorsement, my lord.
Yes, where is it?
32, my lord, in page number. According to the compassionate appointment rules were reviewed, late Srimati K.B. Saroja, KMAS, she died while in the service dated 15/7/2010, and you, the applicant, are married as on the date of application, as you have clearly mentioned that you are married on 15/6/2006 in the first application seeking appointment dated 2/9/2020. as per the rule 2, sub-rule 2 and 3 of the Karnataka Civil Service Appointment of Compassionate Basis, Rule 1996, in force on the said date, there is no provision in the rule for granting appointment on the compassionate basis for the married girl. And the amendment rule dated 9/4/2021 shall come into force prospectively from the date of publication in the Gazette reference for seeking appointment of compassionate basis. Reference number 4, it is hereby informed that there is no provision in the rule to consider your application for appointment.
Rules came into force in 2021, my lords. However, there's another Supreme Court judgment which clearly says the date of death of the parent or whoever it is, that has to be taken into consideration in the case of
But only problem with you is that on a single judge says that in accordance with rules and in force without raising the objection that she is a married.
That's
Same
the
ground you reiterated in this endorsement. it is
endorsement. However, I'll
Will
file,
Find out.
will find out. Minutes.
It also said in accordance with rules.
Please, ma'am.
So if new rules have come into force, it will apply.
In the
2021, my lords, and it is prospective is
File reply.
pledged.
13th March.
Number 8. The Purnima.
Lords, in this matter,
There
was a-
in this matter. My lords, we have preferred and writ appeal, my lords. Writ appeal number 106 of 2025. Maybe tagged along and be heard together, my lords.
Lords, the writ appeal was filed after the contempt petition was filed, my lords. It is a simple case where there was cess that was withheld, my lords, amounting to 82 lakhs, which was directed by the Honorable Single Judge to be returned by KPTCL, my lords, because this is under the Building and Other Construction Workers Welfare Cess Act. We have written letters to them, communicated the order to them, and they have still not paid. After filing the contempt petition, my lords, they have filed an appeal.
When it is filed.
My lords, it was filed on 21/1/2025. It's 21/1/2025.
My lords, this petition was filed on 13th month, my lords. And they were sent a copy which they received on 15th, my lords.
When the present contempt petition comes up for consideration, learned advocate Mr. So and so of the respondent Bbmp stated that a writ appeal is filed in respect of the order which is subject matter of contempt on the present proceedings. Full stop.
106 of
It was stated by learned advocate Ms. So and so for the petitioner in response, that the writ appeal is filed after filing of the contempt petition, his present contempt petition. In any view, when the writ appeal is filed, it would be proper to permit the Bbmp to exhaust its right to appeal. However, it is provided that appropriate order shall be obtained in the writ appeal, which is already filed on 21/1/25, within 3 weeks from today, by removing all of his objections,
Yes, my
failing
lords.
which the compliance will have to be acted upon by the Bbmp. Full stop. Post the contempt petition on 20, today is on 20th March.
Please, my lords.
This is number 9.
Grateful, my lords.
Hitesh Gowda. Here for the complainant.
Yes, fine. What is it? Interim order.
Lord, this is a contempt against the complainants against the order of this honorable court in MFA number 8418 of 2024, my lord. Annexure A, page number 20 is the order passed by this honorable court, my lord. My lord, this honorable court had directed the petitioners on 2 occasions, my lord. One is on 30/12/2024 and 7/1/2025. On both these occasions to produce the child before the Bangalore Mediation Center. However, the respondents have failed to produce the child for visitation. And the manner in which the child was taken away during the pendency of the appeal period, my lord, they filed an execution before the trial court. And during the pendency of the execution, in the gap of visitation, the child has been abducted by the respondents, my lord. And since then, the child has been in their custody itself. And the order passed by this court, the two orders passed by this court are not complied by the respondents, my lord. Henceforth, this present contempt petition.
What is written? 10th March.
I may be permitted to serve on the counsel appearing for the respondents.
In addition to the normal mode of service, learned advocate so is permitted to serve a copy of this contempt petition on the counsel who appeared before learned single judge on behalf of the respondent.
Please, much better.
Number 10.
But,
Subramanya PD.
I am appearing for the complainant in this case, my lord. And but the RFA number 167 of 2008, my lord, that came to be disposed of, my lord, on way of, by of compromise, my lord, joint memo being filed by the party. But under the compromise memo, my lord, he agreed to not to sublet the property and not to make substantial structural changes to the scheduled property. Despite that, my lord, the accused have made changes to the structural.
Where is that compromise?
Next year C is the joint memo, my lord.
Compromise
C.
is where compromise is found. Where is compromise, Mr.?
My lord, annexure C, my lord, attached to the annexure C, my lord.
Page. Joint memo, yes. So what is the breach? What is the breach?
My lord, he agreed, my lord, not to make structural changes to the scheduled premises. My lord, despite that, my lord, he had made changes and sublet the premises to run the garment business. Therefore, my lord, we had issued the notice. My lord, despite
What is the breach?
breach, my lord,
Which-
he has made.
Which part of the settlement is committed breach of?
My lord, the photographs, my lord, I have produced, by which I show, my lord, that
Learned advocate for the complaint is not able to explain to the court as to the which part of the compromise decree is breached. Most of the petition may be listed next on 28th of February, on which day learned advocate may submit by physical appearance. Yes, next.
Number 11. To Sagar V. Shastri.
I am for the complaint, my lord. As per the order of this honorable court, in page number 27, the complainant should, representation should
Notice
have been-
returnable on 7th March.
Please.
Still number 12. Mr. Vinay.
I appeal for the complaint in this matter, my lord.
I have preferred an writ appeal, my lord.
You are appeal.
Against this order, I have preferred an appeal, my lord. And the writ appeal number is 1632 of 2025. The short question is involved, my lord. It may be heard along with the writ appeal, my lord. Whether personal hearing has to be given.
It was
is the
stated
question.
by learned advocate, Mr.
Madhukar Deshpande, my lord.
Madhukar Deshpande that writ appeal number 1634 of 2025 is preferred against the judgment in order which is subject matter of this contempt proceedings. In depth view, the contempt petition along with the writ appeal will be listed on 11th March. Before which date in the writ appeal all the.
I have cleared all the office objection.
There is a delay in filing the writ appeal, my lord.
Please.
Great.
Number.
Green bench matter, still number 13.
My lord, I appear for
Kumar K.
petitioner in this case, please, my lord. Notices will have to go to respondent number 4, please.
To take instruction.
My lord, notice will have to go to respondent number 4, who's a private party and whose lease.
No,
is a-
you were to take instructions. That is the last order. You may not be inclined to issue notice.
My lord, could I seek for some time?
10th March.
Obliged.
Cell number 14. Mr. Chenna Mallikarjun.
But the state government, they've just given us a copy of the statement of objections.
Since you want
But
time,
we need some time.
since copy of the statement of objections is out today, learned senior advocate Mr. So praise for time. Request is exceeded to. Petition shall stand over to which date?
24th.
This 24.
Yes, this month 24.
Yes.
24.
They were also time pounded around.
My lords, my role is very limited, my lords. They have
Because on the last couple of times, they said they wanted time to file objection. If they don't want to file, my lord, state has filed, we'll file.
Status
a
file, my
rejoinder.
lords, no relief is sought against us
Yes,
also,
yes.
my lords.
Yes,
In the
please.
connected matter, they have not even arrayed Union of India as a party also.
So we'll keep it on 24.
Please.
Subject to what
Little
learned
later.
friend says, my lords. They have to defend.
My lord, in the connected matter, I have filed, but in the main matter, I haven't received instructions.
One little later.
Main matter is. my lords,
11th March then.
That
Obliged.
should take care of these objections filed by them, my lord, should take care of the other writ petition.
On same prayer.
Si-
the
Similar,
cases,
both the
same prayer.
matters. But this one objection would take care of both.
Next, 10th of March,
Obliged.
or 11th of March.
Please, connected matter, your lordship, that interim order is granted till the next date.
Interim order is operating here.
Yes,
In the other second.
second matter,
Which second? 14.1.
41.
Interim order which is operating in writ petition number 26096 of 2024 shall continue to operate till the next date.
Much over.
Obliged.
So you're the connected to be listed along with.
My lord, both the matters may be listed
are.
on them.
Both are. Great.
Obliged.
Obligement.
Cell number 15. A. Mahesh Chaudhary.
That's on a very short point, my lords. The matter was pending before the National Grieving Tribunal. That's without hearing the respondent being arraigned, my lords. That is the petitioner before my lords. My lords, the final order came to be passed. My lords, I'm just relying upon my lord's order. My lords, paragraph number 5.9. The lords had dealt with regard to.
This is that matter.
Yes, yes. I was on the other side.
It went to the Supreme Court.
No, my lords, we didn't take it. That's my lords had relied upon a 2023 judgment, my lords, of the Supreme Court, which my lords had deprecated the practice of passing an ex parte order. It's become that, my lords, we also received such an order. Notwithstanding that, my lords,
What is the
the
order of NGK?
my lords, Annexure E, my lords.
27.
Yes, my lords.
What is the order?
That's the operative portion is at page number.
But you are represented.
That's what happens there is that my lords, we have other matters, we log in, my lords. My lords may see it is represented by my colleague with my name. Now, my lords, the opportunity, my lords, the Supreme Court judgment as well as the my lords judgment have gone on to the point that my lords, right of an objection, my lords, is embedded deeply into the principles of natural justice, and that's based on which.
So that is the only slot 226 can be exercised.
Yes, yes, my lords, that's the only slot, in addition to which the main objection.
NJT order is. Otherwise appeal will be lied to Supreme Court.
Yes, my lords.
So we have to say that there is no hearing at all.
There's no hearing, but my lords, notice have to be issued
No,
on
but
the
you-
others.
You demonstrate that you were not heard.
Yes, my lords, I will.
It is seen that you were heard because you were the advocate appearing.
Yes, yes, my lords, I am, my lords, what has happened in this particular case is that, my lords, a closure order, my lords, came to be passed at page number 172, Annexure K. The respondent, my lords, is involved in treating of biomedical waste. My lords, we had issued a closure notice after a detailed inspection personal hearing, and my lords, forming a special committee called a fact-finding committee, my lords. Three things came out which was reflected in the closure order. Number one, my lords, they were not in compliance with the law, which is the Biomedical Waste Rules of 2016. Second, my lords, the land which is being operated by the respondent, which is a leasehold land which is given by the DC of Kalburgi, which has been terminated for violation because, my lords, they try to mortgage or try to create some encumbrance on the property.
Although the order dated 16th January 2025 passed by the National Green Tribunal, Southern Zone, Chennai, which is sought to be impugned in this writ petition, indicates that on behalf of the respondent, learned counsel for the State Pollution Control Board appeared. It is the emphatic submission on part of learned advocate Mr. S. Chaudhary for the appellant board that the order that though the appearance is indicated, the Pollution Control Board was not heard and the order of the National Green Tribunal proceeded ex parte in that sense to culminate into the directions passed in paragraph 27. Full stop. Notice returnable of 12th March.
Seek for the stay of the order.
What is the?
That's the stay of the impugned directions, my lords, which my lords saw at 27. Lords, there's even a recording, my lords, by the NGT that, my lords, there are severe non-compliances. In spite of which they say that, my lords, you revoke the closure order, let them comply with it. My lords, it's, my lords, putting the cart before the horse. The very object of issuing a closure order would get defeated, my lords. If they are saying that let them comply, then you revoke it, let them comply. At point number 3, my lords, the appellant is directed to comply all the violation shortcomings.
So we stay direction number 1 and 5.
Please,
Rest
my
may
lords.
continue.
Please, my lords. Please, my lords. At my lords.
Jumping.
In fact, my lords,
7/12/2024, where is your order?
page 172 minutes. Annexure K. That's what has happened here is we even gave a copy of the inspection report showing non-compliance.
To close operation, process with
And the ground, my lords, the tribunal is invoked its jurisdiction as that, the waste cannot be disposed of. But my lords, the DC has already assigned the entire disposal system to another unit. So no hardship at any point of time could ever been caused.
Is Engage in manufacturing what?
It's not a manufacturing unit, my lords. It is a disposal unit
Disposal.
of biomedical waste. It's called common biomedical waste treatment facility. That's what my lords would be seeing that as CBMWTF. Now, my lords, that has been reassigned. My lords will find that at page number 175 to another unit. So there's no hardship at all at any point of time. And in any event, my lords, another issue. Closure order is issued under the Water Act. That has been challenged. Closure order under the Air Act still subsists. He does not challenge that. So there are two closure orders which have been issued. He just challenges one. And the other he does not even challenge.
So the unit is not in operation as of now?
It is not. So my lords,
Not in operation.
it is not.
Why, how?
That's
How it is not in operation?
because my lords, the minute we issue a closure order, my lords, the gates would be locked, which would be looked after by the DC. Because we also instruct them, my lords, or request them, I would not use the word instruct, but request them to monitor the entire process. In fact, my lords, we had to make DC Kalburgi as a party.
Pressing the interim, pressing for interim order. It was highlighted by learned advocate for the appellant board that the NGT passed following directions without hearing the board. So court paragraph 27. It was submitted that the aforesaid direction may be stated to be examined at a subsequent state after the hearing of the case of the, after considering the case of the pollution board. It was further submitted that it was further stated with the board that the respondent unit which manufactures,
No, it's a waste disposal facility.
which is which operates for waste disposal facility
Is not in operation.
is not in operation.
Yes.
And the operation stands suspended
Yes.
as on date.
Yes.
Then there is no question of granting any relief.
Well, that's the reason being that, my lords, otherwise what would happen is I would face myself under the contempt jurisdiction of the NGT. My lords. My lords, again running up to my lords. It would be, my lords.
In view of the above statement, by way of identity, it is directed that direction number 1 into bracket Roman capital 1 above, as well as direction in Roman capital 5 shall remain in abeyance till the next day of hearing. It is clarified that the board shall be obliged to, appellant board shall be obliged to proceed in accordance with directions in 3, 4, and 5.
Yes.
2, 3, and 4. To inspect, etc.
Yes, yes, my lords. That's may also seek to implead. I had to file an application, my lords. The DC Kalburgi, my lords. Deputy Commissioner Kalburgi. I may be
Yeah.
permitted, my lords,
At this stage, learned advocate for the appellant.
as
seeks
respondent
permission.
number 2.
The Deputy Commissioner Kalburgi, as party respondent, permission is granted, the course titles will be amended accordingly. Full stop. After the amendment carries out, the notice shall also go to newly read.
Ma'am ma'am can take notice for DC.
Post titles shall be amended accordingly. Learned additional government advocate, Ms. Neelafar Akbar, is directed to appear. However, the copy shall be served to.
Very grateful.
Number 2. You serve copy to number 2.
That's, yes, we'll serve it.
There, copy there, so that the authority can properly instruct.
Yes, my lords, we'll do that. We'll do that today itself. It's grateful.
Obliged.
Yes. Bill number 16.
I'm for the complainant.
I'm representing for the accused number 5 in this case, my lord.
There is a small
Accused number
predicament.
5.
But who is for appellant?
My lord, state appeal, my lord.
State of.
But your lordships have already decided this. It's a covered against me. Your lordships have decided this.
What is it?
Would your lordship just bear with me for a minute? Issue relates to rotation of head of the departments in various medical colleges. My lords, the order against which I'm complaining of contempt and the order against which they have filed the writ appeal, my lords, is the order at page number 25. 25 in my contempt.
My lord,
In my
in
contempt.
the
I'm
writ
so
appeal, it is at page number 36, my lord.
If your lordships have writ appeal, page 36.
36 of the writ appeal.
Which paragraph of or internal paragraph of the law?
Internal paragraph number 2, my lords. Page
41.
Page 41.
Today by way of memo.
Yes, my lord. So, my lords, the learned single judge solely relied upon an order passed by the learned single judge in Dharwad, my lords. The learned single judge orders of the Dharwad, my lords, was subject matter of a writ appeal before my lord Justice Arun, my lords, who that bench, my lords, reversed the order of the learned single judge. In my contempt petition, along with the memo, my lords, I have filed that also. The first contempt memo.
I can pass on the order, my lord. Coordinate bench order.
Very well. It's readily available.
Court officer. Court officer. This is the order in the order of the coordinate bench.
Internal page 33, my lord.
Lord, an SLP has been preferred,
Against
my lord.
that, SLP was preferred, in which, my lords, originally there was an interim order of stay of the division bench order, which was granted. Subsequently, my lords, the interim order is discontinued, my lords. Today, my lords, my prayer before your lordships is only this. Either your lordships, my lords, may set aside the learned single judge's order or direct implementation of it. The order of the learned single judge, my lords, is of the year February 2024. It's about a year ago. Therefore, my lords, your lordships may simply follow your lordships order. There is no stay. SLP's order also, it's there along.
By virtue of this order,
My single judge order should have to
by
be.
bench headed by my brother,
Please,
this will stand covered.
covered against me.
That is
That appeal,
Yes,
appeal filed by the
Appeal.
state. Appeal filed by the state.
Will have to be allowed.
State's appeal, my lord, in that coordinate bench judgment where it was allowed. The present appeal is also by the state.
Also, the individual doctors also have preferred an appeal, my lords.
But it's my duty to.
Contempt will not survive.
Against my lord's judgment, my lord, the division, means SLP is pending. That's all that I can say. But that is immaterial. Stay is now discontinued.
This stands covered by this.
Correct, my lord. That's all that I'm saying. Therefore, my lord, in view of that, my lord,
Lords,
it will have to be.
contempt will not
discussed.
survive.
Contempt will also not.
Con-
Contempt. proceedings
Everything will
also
have to
dropped,
be,
my lord.
appeals will have to be allowed, contempt will have to be rejected. So that, my lord, I'll also work out.
Thank you very much.
Grateful.
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 Both are disposed.
May I make one request? I'm sorry, my lords, if it's not. The SLPs are listed on 4th of March. If my lord's order, my lords, could be delivered, so that I'll also tag along.
It will be delivered in today's day.
So grateful, my lord. I'm
The earliest will be available.
grateful. Grateful. That's fine.
They're not reserving the order. It is disposed of today's.
Very well. Grateful.
Grateful, my lords.
Seventeen is urgent, number 18, Mr. TP Muttana.
16.3 is also. Mr. Harish, the earlier matter, two writ appeals.
Two writ appeals, my lord. Serial number 16 and 16.3, my lord.
Are the same party.
No, my lord. First one is by the government. The other one is by the private respondent.
What will the fate of the other appeal? Same.
Same, my lord. Challenge to the same impugned order.
Oh.
2 contempts and 2 appeals are filed. 1 out of it is by the state.
17 is urgent, still number 18.
I pay for the appellant, my lord.
Pardon?
I pay for the appellant, my lord, 18, serial number 18.
18 years.
Respondent.
My lord, that
Inquiry was common.
Inquiry was conducted, my lord, that respondent was found guilty. There were three charges.
Common inquiry.
Three charges were there,
Three charges, three reports.
three report, and inquiry was conducted in one charge. After finding him guilty,
Then ultimately what happened?
my lord.
Ultimately what happened?
Ultimately, what happened is, my lord.
He was
on the
dismissed from the
identical-
service of
on
the matter.
Very same set of facts, my lord, criminal case was registered.
My lord,
Against that, my lord, the matter came up before this honorable court in a revision, my lord. This honorable court has, my lord, discharged my lord, the respondent herein, which amounts to, my lord, it is better than acquittal. That's what, my lord, few judgments and all papers, my lord, I am submitting.
My
I have
lord.
given a copy to the other side also. my lord.
in the
In view of latest Ramlal judgment and, my lord, Justice Dixit Sahib judgment, my lord, if an acquittal happens, my lord, whether it would be honorable acquittal is the question. Here he has been discharged, my lord, even before entering the witness box, my lord. He has been given a clean sheet. Latest Supreme.
Clean sheet in the department inquiry.
Depend on the same set of facts, my lord. The same set of facts, criminal case was registered.
kindly permit me to submit, my lord, in this case.
Can I pass on, my lord? Judgments as well as this honorable court, Dixit Sahib, my lord, Supreme
But the
Court.
evidence in department inquiry will hold good. in
On the same set.
No, my lord.
Evidence in the inquiry.
Yes.
Will it hold good in the criminal proceeding?
No, my submission is, my lord.
No, we
latest
write that
Supreme Court.
normally
On the same set of
it
facts.
is a reverse situation,
My-
but then
The
even
same
then.
set of facts.
My lord, in this regard, my lord, day
Plus,
for
my lord,
this
even otherwise
this
also.
month only, this honorable Supreme Court has delivered judgment, my lord.
But this
Clear.
honorable court, my lord, even identical
That is on
matters.
2nd February.
That is in reverse situation.
Reverse, no, my lord, it here says that even that similar matter and all, the employer has got the right to proceed against him and impose upon him a dismissal. And this case is similar to this case, what we are discussing, my lord.
And says that
May I pass on?
In case of
This set of papers and also,
my,
they're all
these,
part records, my lord.
these judgments, my lord, is similar to this case.
but
Here,
who is for the appellant here? You are for the appellant.
His bank is in the appeal.
I'm bank is appellant,
in
my
the
lord.
appeal.
now
I have been given a clean sheet by the learned single judge after considering the
my
entire
lord,
aspect of
respondent
matter.
was imposed with the punishment of dismissal, my lord. Against the dismissal, he filed the writ petition.
Now why you are in appeal?
My lord,
Why you are in appeal?
because the against punish,
What, namely, by what is the ground you are urging? What is the ground you are?
my lord, my lord, this is a case pertaining to illegal gratification, my lord.
Correct.
In this illegal gratification, my lord, there were 23 complaints against this respondent. Out of, and inquiry was conducted, 11 borrowers that rural, he was heading the rural branch. And he used to collect 10% of commission for each loan granted. 23, out of 23 complaints, 11 complaints came before the inquiry
Proceedings
officer.
are filed.
Lords,
Criminal proceedings are filed.
criminal proceedings are decided in my favor,
Decide in your favor.
in my favor.
No, my lord.
At the discharge, my lord, not even acquittal, discharge before framing charge, this honorable court, my lord.
My
That's
lord-
what I said.
my
Pass
lord,
on the papers, kindly see.
Then
No.
this, it will not automatically
Yes.
help you.
Discharge, my lord, even before entering the, I didn't even charge also was not framed against me, my lords. Plus, my lord,
Then
coordinate bench of this honorable court.
even
I'm-
then, it will not automatically.
I know, even otherwise also, my lord. The my lord, material and record, my lord, shows the other manager who was there, he said, I am responsible for having a lodged in false case, and the papers are there. It has been considered, learned single judge has gone into all the details.
My lord, this,
My lord,
my lord,
coordinate bench of this honorable court, my lord. I am lucky that Arun Sahib's judgment itself, of course. My lord, his lordship said in respect to honorable acquittal.
Yes.
Here it is still higher, my lord. Discharge.
Where is that judge?
Dixit's, these are here. Just
my
the
lord,
cross.
page number 26 of this latest judgment, my kindly read, my lord. And same thing has been repeated. Para 26, my lord, this recent judgment, day before yesterday, it is pronounced by the Honorable Apex Court. Clearly, this entire thing has been discussed here, my lord. Regarding that similarity in the charges also, the Honorable Apex Court says, no, that the employer is not barred by proceeding against him departmentally. That is what the Honorable Court says, my lord, this is the latest judgment.
Learned single
File
judge, my
number
lord, has
26, my
gone
lord.
into full details, my lord, entire details.
There also, my lord, he was acquitted. And acquittal back, my management should charge it. And he was up, that is for illegal gratification money. He was dismissed. Against that, my lord, that learned division bench said, no, because
But in the first set,
because it was acquittal and all, that honorable division bench and all, the setters said order. Against that order, that management filed that, approached the Supreme Court, my lord.
My lord, in the first set, my lord, in the first set, memo with papers are there.
Yes.
Last document, my lord, item number 9, my lords, pertain to very same respondent here. Item 9 in the papers, my lord, memo on kotidini. I have shared a copy on the other side. Memo, the last item, copy of the final order dated so and so, passed by criminal revision petition so and so. Lordship gets that, my lord. Justice Banumat Sahib, my lord. This is very same person, my lord. He was the manager. He had filed the petition. This honorable court, my lord, goes into entire details, my lord. It was at the stage of framing charge, my lord. Honorable court, my lord, takes the view, my lord, that there is nothing in it, my lord, and totally revision petition has been allowed and proceedings have been quashed. My lord, the para 14 onwards, I think.
In respect to very incident, very person.
Very same between Canara Bank and myself only.
Paragraph.
My lord, the para 14 onwards, sir, I think are important, my lord. Para 13 onwards. 13, may I read, my lord?
Yes, on the perusal of this.
My lord, para 13 onwards, by the perusal of these allegations material produced, even though the common charge of 3 accused entering in criminal conspiracy, subsequent charges are the execution of the conspiracy indicate only the role of accused number 1 and 3, and there is absolute no allegations of any role played by the accused number 2 by the petitioner herein. So far as charge number 1 conspiracy is concerned, absolutely there is no material available to show that the petitioner has in any way conspired with accused number 1 and 3. No doubt it is true that the allegation of conspiracy is difficult to prove by way of documentary evidence, and as such, most of the time, court is required to consider surrounding circumstances so and so. In this regard, if one peruses the statements recorded in chronological events, it is clear that, in fact, it was the petitioner who was asked by the superior officers at the bank to practically investigate the alleged frauds, and the present case is only because of the unrevealing facts of by the petitioner. As such, except preamble showing the alleged conspiracy entered into by the 3 accused, there is absolutely no prima facie material or allegation even to point out that role of petitioner is the alleged conspiracy. So far as para 14, so far as second charge is concerned, in pursuance of the conspiracy, petitioner other two got dead animal of so and so J.R. Bhandekar issued by using the forged certificates. Items are shown 1, 3 and all that figures are shown. Section 120B, 468, 471, so and so. Read is section 5.2 and 5D of the Act is concerned. It is to be noted that investigation material now before the court shows that there is no question of the petitioner claiming the amount in the name of say Bhandarkar and misusing it. The records show that the said amount was received by way of check, and the same was directly paid to the account of said Bhandekar. And in fact, during the investigation, said Bhandarkar has admitted that he has withdrawn the amount, the said amount also. Said Bhandarkar in a statement to investigation agency has further admitted that in this regard, he had written letter to the bank about receiving the amount, and he has also signed the necessary bank vouchers in this regard. In view of this glaring documentary as well as oral evidence, in my opinion, there is absolutely no material to connect the petitioner with this charge. The confession of the accused number 1, I'm not accused 1, Malad. He is on the record. And on the facts of such confession, it was accused number 1 who was responsible for the alleged fraud in the charge number 2. And by no stretch of imagination, petitioner could have been involved in the alleged crime. And the said imaginary conspiracy between himself and the accused number 1 and 3. In fact, similarly, the position in respect to charge that is 5 and as such charge number 1. Even though CBI has rightly noted that acts of illegalities and criminal acts are only those of accused 1. My lord, he goes on entire narration. Next page, my lord, about 4-5 lines thereafter, my lord. Section so and so, 5 and 5. Later on, just blindly have included the name of the petitioner as accused number 2, only on the ground of being conspirator without there being absolutely no material in this regard. The only allegation probably against the petitioner is that last charge pertaining to the alleged bribe accepted as the petitioner. Statements of these alleged bribe givers is concerned. Apart from there being no complaint at any point of time by anyone nor any indication in the statement as to the role of the petitioner, according to CBI, charge is in respect of alleged bribe taken the petitioner in the year 87-88. In the first time, it is stated to have come into light at the investigation. So absolutely there is no material, prima facie material to indicate as how the investigating agency has come to know this aspect of after a long lapse of 6 to 8 years. 6 to 8 years.
My
this
lord,
charge has been. My lord, lastly,
Acquittal.
my lord, in this case, my lord,
it is
evidence.
discharge, not
discharge, acquittal, my lord, your lordship may kindly see by that whatever the decision
Discharge.
affects was this page number 26.
It's a discharge.
No,
Not
discharge,
even
that is
the-
what, here also my discharge, my lord, what happened, my lord, in this case, that only 5 minutes I'll take, my lord, to explain this. Here, what happened, my lord, in this case, that he was working as the manager of the rural branch. And he used to collect 10% for giving the loan to livestock loans. 3,000 rupees means 300, 1,500 means 1,050. Like that, when there was a lot of complaints. Then the bank conducted the investigation. And before proceeding with the disciplinary action, that CBI took over the matter. And CBI that conducted the investigation, filed the charge sheet. In the charge sheet, in the trial court, my lord, the lower court, my lord, the respondent filed an application for discharge. The trial court dismissed that. Against that, this criminal revision petition was filed before this honorable court, my lord. Here, this honorable court has discharged that criminal revision petition. The question is, my lord, the same matter has been covered in this latest judgment by this honorable court. This honorable court, my lord, para number 26, page number 18. Your respect, that's it. And this matter is similar. This is also gratification, illegal gratification, and that there was a case and ultimately was acquitted. Here, my lord, page number 26. Here, what happened, my lord? The illegal gratification, he was found guilty and he was dismissed. And then that learned single judge said, because that criminal case he was acquitted and all, he set aside. Then the matter came up before the division bench, my lord. The honorable division bench says, no, that he set aside the order of the single judge on the following grounds. Now, my lord, that the honorable Supreme Court has page number 26. The appellant authorities preferred a writ appeal against the aforesaid order of the learned single judge, which came to be allowed by the division bench, while order dated 2007 with the following pertinent findings. That the decision taken by the appellant authority to initiate departmental proceedings against the respondent is unassailable. The findings of the learned single judge that in case the appellant authority is permitted to hold inquiry into the charges, it would be giving an opportunity to the employer to sit on appeal over the findings recorded by the High Court in criminal appeal, decided by judgment dated 6 July 2004. The two proceedings, the criminal trial and domestic inquiry, in which the same evidence is to be evaluated, is distinct from each other. Therefore, even if the inquiry officer comes to a different conclusion, it would not be a reflection on the findings of the given by the judge in a criminal court, be that trial court or High Court as court of appeal. Many witnesses have consistently narrated about the confessions made by the respondent before the CBI at the time of its trial.
But
Here, my lord,
in my case.
Here, my lord, that these witnesses who came before the inquiry officer, they were not called by the CBI. These people that were 11 witnesses came and they said that they have paid the illegal gratification and they were cross-examined. The reform was the same. Therefore, that is, and this issue is very clearly mentioned by the disciplinary authority as operator authority. Next, fourth, the division bench relied upon the judgment of Commissioner of Police New Delhi, Narendra Singh versus to hold that even a confession made by the employee could be admitted in evidence, the department inquiries and observed that last fire, my lord. From the above, it would become apparent that this cannot be said to be a case of no evidence. It cannot be said that even if the entire evidence is accepted as true, it would still lead to the conclusion that the respondent number 1 was innocent and having committed any crime. We therefore hold that the initiation of a department proceedings against the respondent number 1 cannot be said to be vitiated or without jurisdiction. The division bench also held that the ratio of the court judgment in the GM Tank Supra would not apply to the case at hand. The judgment of the division bench has been affirmed by this court with the dismissal of the special leave petition filed by the respondent. Hence, these findings recorded by the division bench of the High Court in the earlier round of litigations have attained finality among the division bench in the impugn judgment, while allowing the writ appeal filed by the respondent virtually overturned these pertinent findings recorded by the judgment dated 6 August 2007 rendered by the division bench in the earlier round of litigation. Despite such judgment having attained finality, hence this account alone, the improved judgment dated 1st March 2022 is unsustainable in the eyes of law. Further, we are unable to sustain the findings of the division bench that a non-examination of the complainant is fatal to the case of the appellate authority. It is well settled principle of law that even a criminal case pertaining to the demand and acceptance of illegal gratification, the courts are empowered to record the conviction where the decoy turns hostile and the prosecution case is based purely on the evidence of the trap erring on the officer and the trap witness. In this regard, we are benefited by the judgment of so-and-so. 29, in the case at hand, the subject matter concerns, my lord, in the case at hand, the subject matter concerns the domestic inquiry where the strict rules of evidence prohibiting admissibility of confession statements recorded by the police official do not apply. Likewise, non-examination of the decoy cannot be treated as a fatal in the domestic inquiry where the evidence indicates the delinquent officer as has been held by the court in the case of Narendra Singh, even a confession of the delinquent employee recorded by the trafficking officer during the criminal investigation can be relied upon by the disciplinary authority. It is pertinent to note, last 31, the division bench in the imputed judgment further observed that disciplinary authority and appellate authority did not consider the representation of the respondent and acted without application of mind by imposing a penalty of dismissal from services against the respondent. And in perusal of the orders passed by the disciplinary authority and appellate authority, we find that the representation submitted by the respondent has been duly adverted to and objectively considered by both authorities, and the same were found to be devoid of substance. It is true that the disciplinary proceedings is not necessary, but the disciplinary should deal with each and every ground raised by the delinquent officer.
That is being done is my submission. That is being done by the learned single judge. Lord, he forgets, we all forget how the learned single dealt to.
Long.
37.
Long gap. That's our learned advocate, Mr. Your TP Mustanna for the appellant and learned senior advocate, Mr. So-and-so, assisted by learned respondent.
One request made, subject to.
Original petitioner at length, the learned parties stated that they argued the appeal. Finally, they further stated that the pleadings are complete and no further are required to be added or supplemented. Yes.
Only submission is, my lord, forgetting, my lord, criminal side. On the service side, my lord, learned single judge has gone into entire aspect of the matter. There is one Shanbag, an officer. He has given admission. He gives by means of a letter that he has given a false complaint. He is the person who has committed all this. All these aspects are seen. Let us, my lord, forget for a moment one criminal case. Though I am discharged, honorably forget. Civil side, my lord, on the service side, learned categorically gone into.
But my illegal
37 page judgment, learned single judge said, my lord.
Illegal gratification, all the cases have been proved.
May I read, my lord, few lines of the judgments? May I read? Your lordship permits me. Learned single judgment, my lord, learned single judgment, considering every aspect of the matter. After 8 years, complaint is lodged. One Mr. Shanbag, my lord, gives a letter in writing that, my lord, he has committed all this. There is no, my lord, fraud on his part. All these aspects have been referred to. And, my lords, regarding 269 loans, my lord, they were sanctioned even prior to the, my lord, tenure of the petitioner. Each and every has to move, my lord. Then, my lords, regarding, my lord, coming to the judgments, my lord, I have cited here, coordinate bench of this honorable court, my lord, item 6 and 7, kindly see. Item 6 and 7. Identical situations, my lord, where I have given set of judgments, my lord, to your lordship, my lord, 6 and 7. Their lordships, my lord, when the acquittal orders are there, lordship said, my lord, if the matter exactly covers, there is nothing to be done, my lord. 6 and 7. My lord, the 6 is by Justice Arun Sahib, my lords. Of course, subject to his lordships have gone into, my lord. There is a comparison, my lord, between what is being done in the criminal court and the other, my lord. His lordship holds, once a clean chit is given, my lords, that virtually only question would be, my lord, honorable acquittal. I am still far, my lord, far higher. 6 and 7, my lords. Just Narendra Sahib, my lord, and Justice Arun Sahib, my lord, I have the lucky to have this, my lord. And Ramlal's judgment is also flagged, my lord, at item 8. Following that, my lord, Dixit Sahib latest, my lord, latest judgments at item, my lord, at item 9, my lord, item 9 in that judgment. My lord, his lordship said what is meant by honorable acquittal, my lord, goes into, my lords. Where it is a question, my lords, of idea of honorable acquittal, my lord, item 9, my lords. Division bench, coordinate bench of this honorable
No,
court.
7. 7 is also relevant.
Item 9.
7 also relevant. Item
7 or 6, my lord, 6, 7 are consecutively, they are in my favor.
also 9.
9 also, 9 also. Following, my lord, the Ramlal's judgment, my lord, his lordship Dixit Sahib, my lord, item 9. Idea of honorable acquittal is not easy to define, although it can be illustrated. If an accused is discharged at the pre-trial stage or the criminal proceeding launched against him is quashed, there is no difficulty treating the same as cases of honorable acquittal
Where you
for the limited purpose.
where you are reading?
Item 9, my lord, flag judgment.
Correct. Where we are reading?
In the head note itself.
Head note itself.
Head note itself. Departmental inquiry, the head note is there.
If an accused is discharged.
Relevant paras at 5 and 7, they are referred to in the main judgment. And above all, my lords, my submission is, even on facts, my lord, we are at. One legal representative. If it is an ongoing, if it is a discount, Lord, one request subject to, my lord, if I am not burdening your lordship, my lord, learned single judge, my lord, has learned single judge, my lord, has gone into
Here, when was the inquiry proceedings concluded?
is there.
Okay, in the inquiry proceedings, he was held not guilty.
Yes, on guilty. Yes, in the appeal also. Then we filed, my lord, the writ petition, learned single judge. Learned single judge has passed all the charges, my lord, and the entire.
So continuously, he was held not guilty.
Not
In the disciplinary proceedings also held not guilty.
yes.
Charges not proved. Then the appeal also.
Appeal was confirmed, but the learned single judge, my lord, has gone into also. May I read the portions, I think?
No, discharge order was passed after the conclusion of inquiry.
My lord, discharge was long back,
Long back.
238 itself, judgment was 238.
So his contention is there by.
Yes, long back even. Thereafter the complaint is, my lord,
No, my lord.
my lord, the
Oh, they are-
12th of November
We are
238 is
considering.
judgment.
We are not concluding. We are only considering.
Yes.
The argument is that once there is a honorable acquittal in discharge itself,
Yes.
then why should?
It's higher footing is made.
Higher footing, that's
what court says.
higher footing.
Yes.
Higher footing in terms of the degree of evidence.
My lord, the criminal case was ended, my lords, in on the 12th of November 2008. Thereafter, my lord, this is lodged. That's what Learned Singh also said. My lord. After so many years, he said it has been, these complaints are brought. That's what Learned Singh judge has spoken to, my lord, and said, my lord, at page 60.
Complaints regarding the same event, same incident.
Very same.
We reserve for judgment.
And now he is no more. That manager is already in the second world. All his LRs are only claiming benefit. That's all. There is no question of reinstatement also. Only to be confirmed. What is the?
Also, the learned single judge, one sentence he mentions, the witness has said he has given the bribe, but he has not mentioned to whom it has been given. He has
Not his other manager, sir. Not this manager, sir.
There was in the rural branch only 3%
Not this
manager and officer and clerk.
Not this man.
Nobody is there.
We will consider resort for judgment.
Very. May I, my lord, submit synopsis like notes?
You, both of you can
Yes,
submit. it.
yes, great,
Within a
great.
week. within
Very,
a-
very great, very grateful.
Within a week.
It's very great. And thanks for, my lord, very grateful for patient hearing. We all, both the lawyers always quarrel. And your lordships may have to, my lord, take patience into it.
Two judgments are.
Thank you, sir. Thank you. Yes.
My lord, judgments are already flagged, my lord, but only thing is synopsis, my lord, I'll be able to.
You, but
Event,
do-
event and date wise.
within 1 week.
But definitely, immediately we'll do it.
Yeah.
It's our duty. Grateful.
Seal number 19, the state appeal.
For the appellant.
Delay.
My lord, there's a delay of about 466 days, my lord.
Notice has gone or not?
Notices have been served, my lord. They are in contempt.
I
They filed a
take
contempt
notice,
petition.
my lord.
Also,
First and second respondent.
page 220 is the application seeking condonation of delay, my lord. Paragraph 6 of the affidavit, my lord, is the explanation. There was a review that was filed, my lord, in this matter.
This is what? Appeal.
Please, my lord.
You said review petition. Your affidavit review petition. Described as review. When did you apply for the certified copy? Not stated. Dispose of the petition on 21st July 23.
Please, my lord.
Opinion was received from the government advocate stating that is not a fit case. What was the opinion of legal department?
Pardon, my lord.
What was the opinion of legal department?
Lord, legal department initially gave an opinion that it is not a fit case, my lord.
No, that opinion is given by the learned government advocate.
Government advocate, my lord. That
And-
is because, my lord, on parity.
Are you referring the matter to legal department?
No, my lord, internally what happened, my lord, in the impugned order came to be passed by relying upon a case of Venus case, my lord, where the UGC
No,
pay scale was.
we are only on the delay aspect and the procedure of
Very well.
your
Please, my lord.
decision making.
Lord,
The
initially,
government advocate says no, that this is a case not fit to be appealed against. What is the next stage you?
my lord, it is at the stage of the legal head of the department, my lord,
Legal
Please.
department.
of the
So what-
department, my lord.
Here, what is the view of the legal department?
The legal department thought it fit to file the appeal for the
The
reason.
legal department,
Please, my lord.
where is that?
Lord,
Then who took the decision to file appeal overriding the opinion of legal department?
no, my lord, it is a legal head, my lord. Head of the legal cell of the department, my lord.
Legal department recommended for filing appeal.
Please, my lord. Initially, from the office of the Advocate General, an opinion was given that it is not a fit case because the order of the learned single judge, my lord, relied upon a Venus case, my lord. On parity, the relief was granted. Later, the order in Venus case was also withdrawn by the government. Therefore, my lord, the decision was taken to prefer an appeal. Delay mechanism.
You can't do-
Regarding delay, I will leave it to the lordship.
Relocate. Yes, now appeal today itself.
No, my lord, I will leave to your lordship, my lord, because this is a matter where there is an order to extend the UGC pay scale to the writ petitioners, my lord.
12th of March will take.
Please. My lord. There is a connected.
Appeal may be listed on 12th.
Please.
IA allowed.
Please.
IA allowed delay con. Not to be.
My lord, there is another connected appeal, my lord. I filed the same appeals together, my lord. It's a common order passed. I think by mistake, I moved both the matters and both the matters were directed to be listed yesterday, my lord. By mistake, they didn't list it. They have listed only this matter, my lord. Connected appeal is 81 of 25, my lord. That's the main matter. This one, I was not party. I sought permission to prosecute because that order is affected me. my
So
lord.
you want this to go with that?
Together, it may be called together and I may be heard.
Writ appeal number 81.
81 of 25, my lord.
25. On which date?
Any date, my lord. Nearest date because there's a transfer order.
14th March.
My lord, nearest because a transfer order, they may displace. me.
Transfer order. 27th. 27th February.
So by 21. SB Mukanappa.
Pay for appellant in this. My lord,
Yes. Delay of 23 days.
yes, my lord, before the learned single is, my lord, the TP Mutana has appeared on behalf of the respondent. Kindly take notice.
I annotate the file, my lord.
You can appear. Welcome. Yes. So, heard on with respect to parties, delay of 23 days is explained in the accompanying affidavit to make out sufficient cause. Accordingly, IA number 24 is allowed. Delay is condoned. IA. Now, what about the appeal?
Kindly after next week, no, I will argue.
Work. What is it about? It next week. Penalty.
Yes.
Not next week, then it will go to 19th March.
Much.
Till number 22. Avit seat, 14%.
No, please, okay. Your lordship, may.
Yes.
Yeah. Your lordship, the appellant herein was a probationary officer and he was under probation for 2 years. And as per the email dated 31/7/2019, appellant was supposed to be confirmed. However, on 2nd of August 2019, the appellant was terminated citing unsatisfactory work performance and conduct. The appellant has also, the appellant was not served with any notice or any adverse remarks were not communicated. Against the said termination, your lordship, the appellant has preferred an appeal and the appeal was not considered.
So you will be appealing for all the respondents?
Yes,
All.
respondent 1 to 9.
2, 9, all.
And the appeal copy was given.
Order of discharge, page number.
Page number 214, Your Lordship. It's volume 1, 214. At page number 209, Your Lordship, dated 31/7/2019, I was named to be confirmed. It is at page number 209. Just 2 days before. My name appears at page number 211, second from the top, Your Lordship. In the entire period, there was no adverse remark was ever communicated to me.
Where is delay application? What about delay?
Your Lordship, the main contention before the learned single judge was that whether the appeal that I have filed against the termination order is maintainable or not. My appeal was not considered by the respondent bank.
There is a delay of 199 days in filing the appeal.
My lord. The view of the learned counsel was that the appeal is not maintainable. And I have also preferred one review petition after the writ petition. Hence, the delay comes out to be actually 96 days, 76 days, Your Lordship. And if the Lordship can
see the IA 2 of 24, I have filed one judgment of the Honorable Allahabad High Court, which clearly says that in the same matter, the appeal was considered by the respondent bank. And in the meantime, Your Lordship, in the meantime, I have also tried to connect with other advocate to take up the matter, and due to the general election, there is a delay of 76 days, Your Lordship, because I have preferred a review petition after this writ petition, Your Lordship. If my friend agrees, Your Lordship, the delay may be condemned in the interest of justice.
Writ appeal copy I have not received, my lord. Writ appeal copy I have not received. I'll get it from him, my lord. Delay, hand out, my lord.
IA number 1 of 24. Heard learned party in person, Mr. So-and-so, and learned advocate, Mr. So-and-so, all the respondents who appears on notice of the court. This application is filed seeking condonation of delay of which has taken place in preparing the appeal. In the accompanying affidavit paragraph, the applicant party in person stated that after the deliverance of the judgment and order of a single judge, he consulted several lawyers to request them to appear on his behalf in the appeal. However, nobody acceded to, since it was very far from Odisha. It was also stated that in the subsequent times, sir, the father of the appellant was admitted at hospital, which further led to passage of time in handling the appeal. It was highlighted that when the review was filed against the judgment and order not to be appealed against now, and during the pendency of the appeal, the time passed, time was, and pendency of the appeal also consumed the time, which was a bona fide litigation. So submitted that all these aspects make out sufficient cause and the delay may be condoned. Looking to the reasons supplied, it is not possible to attribute any negligence or indolence on part of the party in person in preparing the appeal. Delay of 199 days can be said to have been explained with sufficient cause. Therefore, wherever it is condoned, the application is allowed. Now, appeal. Any other day?
Other day, my lord. Appeal copy I have to get.
Give copy.
Your Lordship.
Appeal shall be listed on which date?
Date when? Any date.
Where is the order of discharge? Termination of probation period.
Your Lordship, page number 214, Your Lordship. It is a movement order, Your Lordship, without any communication of adverse remark.
That is, may not be true, my lord, that all is appraisal.
The appraisals were never communicated to me. They were communicated after 3 years.
Appraisal was negative.
No, it's non-satisfactory. Not at all. It is the orders.
And the termination or order is not as simple as it is worded, Your Lordship. At page number 209, before 2 days, I was named to be confirmed. 209, Your Lordship may see. 31/7/2019, that is 2 days prior to the termination order dated 2/8/2019. My name appears second from the top at page number 211.
Consider when you copy. 19th March,
Your Lordship,
19th March.
can it be little earlier? Your Lordship.
You copy, you read the appeal, then prepare himself.
Your Lordship. Obliged, Your Lordship.
Number 23.
May please, your lordships. In this writ petition minute, the writ petition was filed with a single issue of lack of education for the children who market these items minute on the traffic junctions. But the Honorable Court minute expanded the scope of the writ petition for the entire state and called for reports from the Karnataka Legal Services Authority. The shocking reports were received minute to the effect that these children are used for sex in the night. The reports are there minute in that regard. Several orders minute, just one line I may be permitted to read from the earlier orders of this Honorable Court minute. Now, the first order is on 13/10/2020 minute. 7 in the middle minute, the issue raised. The first order of this Honorable Court, 13/10/2020.
.11.
30th October 2020. Orders of this Honorable Court.
End of ownership in this High Court.
It's not.
Yes.
You last have tomorrow, then I will get only the orders.
In fact, I am not able to adjust the sequence of orders arranged in this side
Yes, madam.
after 1 year. Finding out the orders.
I shall just pass on this minute.
Yes.
It is surprising to know that in a petition raising serious issue concerning violation of fundamental rights of the children, the fourth respondent has not cared to appear before this court. So and so. Then little later, the issue raised by way of this petition is of considerable importance. The attention of the court is invited to the fact that children are forced to sell toys, flowers, etc. on the streets of Bangalore, and in particular a traffic junction. It cannot be denied that large number of children are forced to do such activities in the city of Bangalore. Then next date, 18/11/20. We have perused the statement of objections filed by the state government. The issue raised in this petition is confined to city of Bangalore, where it is found that a public place of the city, such as traffic junction, etc., children are forced to sell toys. Then we are 30/11/2020. Both the Bbmp and the state government have not responded in terms of the order dated 18th November. They have not taken any initiative. We therefore direct the Karnataka State Legal Services Authority. Then Millard. Millard could kindly turn to 12/2/2021. A about 10 lines, 20 lines from the top, Miller. The mapping work of the vulnerable spot was done till 29th January on the basis of the observation made while doing the mapping work of the vulnerable spots in the city. Approximately 886 vulnerable children were found at 432 hotspots. A reference is made to a mobile app VR for children, which has been developed on the basis of pro bono and so. Then Miller, same about paras 6 and 7, the state government will have to also respond on what is stated on in the report dated 11th. We direct the registry to fix the case for further hearing in the conference hall because the court felt, Miller, these are sensitive matters, therefore the matter should be heard in conference hall, Miller.
Yeah.
Then Miller, paragraph 10 of the order dated 18/2/21. We also make it clear then in what manner the rights of the children can be upheld can be decided only after proper collection of the data and analysis of the same. Then paragraph 11, while we say so, we must make it clear that during the survey, if any cases of child trafficking are noticed, or it is noticed that some children are victims of a very serious offense, all the concerned will be free to take appropriate action in accordance with law. Then paragraph 15, we make it clear that the presence of the stakeholders, they need not come. That's what the court said. Then para 13, order dated 23/4/21, about 30 lines from the top. This court fixed a special hearing of this petition in the conference hall they referred to. Then para 2 of the order. A reading of all the reports and the perusal of the data collected shocks the conscience of the court. Then little later, the results of the survey are shocking. 534 children were found involved in child beggary and 186 children were found to be involved in child hawking. Then paragraph 5, from the reports placed on record, it is revealed that there are serious cases of child trafficking in the city. Then the matter went to Madhya Pradesh also, as it was revealed that there were allegations of sexual abuse of children in the said institution, containing allegations of interstate human trafficking against the said unregistered institution. The state government will have to inform the court about the action, if any, taken against the accused persons and the said institution. Para 7. Now coming to the final report, it is noted therein that on 6th March 2021, at night hours, one of the members of the DCT West Zone met a person who was proposing to sell a trafficked child for ₹50,000. This information was immediately communicated to DCT Crime 1 by officials of it. Is complained in the report that no action was taken. In fact, in the report it is said, he says, don't disturb me in the night. We direct the state government to produce on record up-to-date reports on the investigation carried out in crime number so and so. This suggestion requires immediate consideration. Then they refer to in para 10, section 107 of the said Act of 2015 reads as under. In every station, at least one officer not below the rank of assistant sub-inspector with aptitude, appropriate training and orientation may be designated. Then para 2, the state government shall constitute special juvenile police units in each district. Then para 3, all police officers of the special juvenile police station shall be provided special training. Then para 11, have not appointed any part in the state of Karnataka. The state government shall file a compliance report regarding compliance with it. Then the state is under an obligation to implement the provisions of the said Act. Then para 14, almost end These are the salutary provisions which are immense importance. It appears that the same are not being followed at all. It will be appropriate if the state government conducts training workshops for the benefit of the members of the CWC in a phased manner. Then paragraph, we propose to hear the state government on the next date and pass appropriate orders. Then paragraph 18, we direct the state government to file a detailed affidavit for reporting compliance in terms of the directions, observations made in this order. The affidavit shall be filed by the state government by 25th. Even the Bbmp shall file an affidavit by the said date about the steps taken to provide education to the children. Then para 20, We propose to issue detailed direction in this behalf on the next date of hearing. Then just about the last date in 15/6/21, last paragraph. State government has not taken any action. We direct the learned additional government advocate to provide copies of all the reports to the Commissioner of Police, City of Bangalore, who shall personally look into all aspects and report to the court on 18th June about the action taken, action to be taken or proposed to be taken by the state government. Then on 18/6, the investigation status report are placed on record by the learned additional government in the sealed cover, which will be considered on the next day. The memo filed with the state government are taken on record. Copies thereof be served to the learned counsel for the petitioners. Then 26/10/21, learned additional government advocate appearing for the state response undertaking that copies of the report dated 12/7 submitted by the police inspector would be provided to the learned counsel for petitioner as well as learned counsel for the respondent in next 3 days. Learned counsel for the petitioner may go through the state. The state government shall also respond to the report signed. So then Miller. Para 12 of the next detailed order, Miller, that's passed on 15/11/22. They have referred to the important feedbacks as well as the suggestions of the respective state. Now we expect the state authorities and the Bbmp to file the response complaints report qua the above referred suggestions and recommendations. We also expect further response complaints report by the Secretary of the Government, Department of Women and Child. We also expect immediate complaints from the Bbmp regarding the direction issued by this court on 8/9/2011 in WP number 10,075 of 2000 regarding deposit of 90% of the Beggar cess with Central Relief Committee. Passing for a moment at this stage, what had happened in that writ petition was.
Anybody has filed reply?
Please, my lords, if my lords take order dated 1/12/2022, a detailed response was filed. 1/12/2022, my lords get the order. My lords, 1/12/2022. My lords, para 4 onwards, my lords. May I read, my lords? Para 4. The compliance report submitted by the state government is on the thoughtful and extensive recommendation of respondent number 6, Karnataka State Legal Services Authority. The compliance report of the state government is a comprehensive with relevant data, statements, facts, and figures. In para 4 of the report, a tabular statement is made referring to the recommendation submitted to the court by KSLA in its memo dated 15/11/22. In response to the first recommendation, strengthening of Childline 1098, in the column updated report and action taken, it is stated that standard operating procedure for new framework is yet to come. It is stated that a call by any child to 1098 for emergency assistance will get transferred to 112 seamlessly with a click of a button on the dashboard. In case of a call of emotional or psychological support, 1098, the call would be handled by the trained operators in 1098. My lords, next para. Insofar as the second recommendation of sensitizing the Child Welfare Committee is concerned, it is stated that the term of the expired on so and so and tenure extended periodical. Now the process of appointment so and so. Para 8, my lords. The next recommendation was rescue operation. It is stated that the updated report on action taken, column 21 children have been rescued and placed in CCI for care and protection. Annexure R10 is produced in support of the same. It is stated that the police department have rescued children from begging in the city of Bangalore from 14/6/22 to 9/11/22. In the special drive, totally 75 people have been rescued, including 30 girls, 21 boys, 24 mothers. In this regard, a table is annexed in compliance of the report. My lords, may now kindly turn to the next, my lords, para 18. As can be seen from the compliance report, major steps are taken by the state government. We hope that the state government will continue with these steps and also make efforts to adopt any other additional innovative steps. The state government may submit the details of the same by way of the additional compliance for the next date.
Now, please see.
Additional compliance is also filed, my lords.
No, you are reading for some your compliance report or?
This compliance report which is recorded by the Honorable Court, my lords, and by way of an order, daily order.
Where is your compliance?
My lords, compliance report is dated 1/12/2022. It is filed in the court, my lords. 1/12/2022.
What about BBMP? You file any response?
No, my lords, I appear for Legal Service Authority.
Legal.
BBM. I appear for BBM.
What about you?
We have filed an affidavit and document on 21/4, 2023.
My lords, the major question which was being heard by my lords was whether the beggary cess which is being deposited to these urban local bodies are being sent to the government. So on the last date of hearing, there was a direction to BBMP to find out whether those monies have been deposited. They have filed a memo to that effect, stating that beggary cess has been deposited.
Actually, it's not correct. They have filed the report. I can point out from that itself, it has not been deposited.
BBMP
From that
will have-
report itself. That's the one they have filed it on 28/24. Is this one, madam?
5/11/20. 5/4/24, BBMP.
No replies of BBM.
Tell you file.
One reply appears to be in file, but the court says that we expect better and proper response from as the response is filed today is not at all satisfactory. We therefore direct the BBMP to file additional affidavit on or before 16/12/22. Is it filed or not? 16/12/2022.
Subsequently, another order is passed. That is on 15/2/2023. There it has been referred to, and the court was not satisfied with the report filings. It is there, minutes on record.
What happened?
May I just read it, minutes? 15/2/2023 is the order passed.
Yes.
Paragraph 7, apart from the above steps taken by the Women and Child Welfare Department, it is stated in the memo of complaints that on periodical basis, radio jingles about child protection schemes will be broadcasted through All India Radio for the entire month of February 23. Also, information and posting about different issues of child protection will be displayed in Doordarshan before the daily news during the entire month of February 23. Certain diaries and calendars for this and so with child protection scheme information are also printed and circulated to all stakeholders. Further, by a separate memo, compliance dated 6/2/23, the state government has also placed on record the details in a tabular form in respect of beggary cess collected from various panchayats in the state by district wise and remitted to the government. Thus, can be safely be said that on major issues, there is no positive response from the state government. Today, the Learned Counsel for BBMP has filed a memo on behalf of the BBMP stating that the BBMP has deposited an amount of ₹10 crores to the Secretary, Central Relief Committee, Bangalore on 23. A copy of the demand draft is placed on record for perusal of this court. The said memo is taken on record and marked as X for identification. Now, as we have already referred to the memo of complaints filed by the state and communication forwarded by the superior police authorities dated 21/23 and 9, it would be useful to seek response from the state government as to whether any steps are taken by the subordinate police officers or by in-charge officers of the concerned police station in respect to these communication. Accordingly, we direct the state government to file such a response by way of an affidavit or memo within 3 weeks from today. We further direct the BBMP to deposit the remaining amount of beggary cess collected and retained by the BBMP and forwarded to the Central Relief Committee of the state government within 3 weeks. Then we had last of the order, I would like to read. Paragraph 4 in the order dated 21/9/23. Though the stand of BBMP cannot be accepted as a wholesome for the reason of BBMP cannot utilize particular funds to make good its financial constraints, at the same time, as it was observed by us before, that respondent BBMP has shown some positive response by depositing another sum of rupees 20 crore. We deem it appropriate to grant some reasonable time to respondent BBMP, although its request for grant of 6 months for making the payment is too long. We direct the respondent BBMP to clear the dues to the tune of rupees 55.65 crore plus rupees 2 crore within 4 months only. What is the Beggar says is like this, Milad. We pay every resident in Bangalore, we pay property tax, Milad. Suppose we pay 10,000 rupees as the property tax. 2%, I'm just giving figures, Milad. 2% is taken as Beggar cess. So 10,000 plus 2% is collected as Beggar cess. So that comes to 2,000, 12,000 we pay the property tax ultimately. Out of the 2,000, BBMP can keep to itself 10% as administrative charges. So that means 2,000 minus 10% is, it becomes 1,800. But what was happened is that entire 2,000 is taken by the BBMP. It has not been transferred. And now, Millard, the government has filed a report, Millard, and I have a copy of that report. This has been done by every panchayat, Millard, throughout the state. My lord, is the copy of this, Millard.
We have filed a memo.
Every person. Well, they collect the money, they don't transfer it to the, as a result, Beggar is, say that is Central Relief Committee, they are not in a position to work and Beggar's interest is not taken. We are now seeing more and more beggars because they are not in a position to take care of the beggars there. And the entire money is taken by the, in fact, His Lordship Justice K.R. Singh, when he was the Honorable Chief Justice here, he said, we don't even believe your checks, so therefore deposit the DD. That's why they are now giving demand drafts, not the check. In the other petition.
Yes, BBMP may file further reply.
Yes, ma'am, it's been filed further.
By
Madam, as per the
19th.
order, we have paid 55.65 crores. And we have made it to the court also on 5th April 24.
It's a recurring, Millard, it's not old balance they have to pay. Suppose now they have been saying that they have collected so much of tax in crores of rupees, Millard. Again, that cess also will be there, that they cannot keep it to themselves. They had to transfer it to CRF. That is their own circular. Government circular is there that they cannot retain. All these are discussed in WP 10,075 and that is extracted in one of the orders here, Millard.
Learned counsel for the Bbmp states that he will file further reply.
3 weeks time may be granted.
Since the petition belongs to the year 2020 and looking to the importance of the subject matter, the further reply, if any, shall be filed on or before 19th of, on or before 3rd of March. The petition shall be listed on 17th March.
Great.
So number 24.
Appearing for the petition in this case, but I seek for password in this matter. I seek for password, my lord, since senior counsel is appearing.
What is it? Like,
My lord, shops of belonging to the Gram Panchayat are in the possession.
auction.
Yes, 47 commercial shops.
So they are being given without auction.
Yes, and they have been given to panchayat members and their relatives also. My lord, I wrote to the government seeking for an intervention in this matter, but I haven't received any response so far. Mr. Somayaji appears for the,
I'm happy for, at 2 to 4. The shops are distributed, I can say, shops are distributed to the members of the Gram Panchayat. It has not been auctioned for the last 25, 30 years. My lord, we have become helpless because the members, they will not pass a resolution. You want to evict them also, they have to pass a resolution. They will not. They will not take steps to auction also.
The members of the panchayat running the shop.
yes.
Many, 27 out of 47.
Without auction. That's it, that's it.
They are getting 47 and about 60 my lord, shops.
No,
They are getting only 17,000 as rent, total rent. Rent varies from 50 to 1,000. This is happening not only in this Gram Panchayat, in all over Karnataka it is happening. Because law is also, my lord, they take the shop, after the period expires, then we have to proceed in accordance with the Karnataka eviction of unauthorized occupants.
You are for panchayat?
Yeah,
Yes, my lord.
I'll reply.
I appear for Panchayat.
I'll you reply.
2 to 4, I appear. I appear for, my lord, respond number 2 to 4.
File your reply.
Yes, my lord, I'll file. Whatever is said is correct. There is no dispute regarding that. That I file my reply. Details I'll give. All details I'll give. That is better. Within a week, within a week I'll file.
You file reply.
Yeah.
In your interest.
Yes,
Don't say like that.
in the interest of the
You may
public.
write, but still file a reply and then say.
Yeah.
That reply is wrong.
In the interest of the public. No. I'll file a reply in the interest of the public.
Respondent panchayat shall file reply within 2 weeks.
Yes.
The appeal shall be listed on 12th March at 2:30, looking to the importance of the subject matter.
Still number 25.
It's in 25. Appear for my friend in 25 minutes. Also says the AERC's regulation, which says that they should provide electricity despite illegal
Without,
construction. Once they have filed the response. I just want to point out that in December 24, there's a judgment of the Honorable Supreme Court where they issued further direction that a specific direction says that no electricity connection shall be provided if there's illegal construction.
without?
Without occupation certificate. There shall be
Several directions were issued by the Supreme Court.
Just
Lord.
pass
General
out the
direction.
judgment, my lords, 2024. Well, I think same judgment. Paragraph 21, number 4.
Are you referring to this? 24, Rajendra Kumar.
Rajendra Kumar. His Lordship, Rajendra Kumar, Parjatia and other. Para 20, para 21-4 says all the necessary service connections such as electricity, water supply, sewerage connection, etc. shall be given by the service provider or both to the buildings only after the production of the completion of occupation certificate. So the law is.
But only difference is, my lord, there was no regulation considered in this judgment. There is a specific regulation in Karnataka where we have dispensed with the production of occupancy certificate because it is for the municipal corporation or Bbmp to take action if there is a deviation in the building plan. That was not considered in this judgment, in the Supreme Court.
Is
judgment.
better or worse?
Lord, this is a general direction, but since there is a
No,
specific,
in Karnataka, there is such regulation, it's a better position or worse
but
position?
if your lordship sees the amendment, my lord, why that amendment was required was because of Bescoms. There are a lot of buildings which have been deviated from the sanction plan. They did not have the electricity. Under section 43 of the Electricity Act, there is a duty cast on the Bescoms or the distribution licensees to provide electricity to everyone. And if there is a deviation, it is for the other authorities to take action, but they can't say that don't give the electricity connection to the people who are in need of that. And they are in occupation of a particular building.
My lord, that's because Bescom wanted to sell power. Not that they were required to consider whether the building in question is legal or illegal. That's precisely the reason the other writ petition came up before this honorable court. This honorable court took so much notice of all this and registered a writ petition to the registrar of this honorable court. And the large-scale violation of building bylaws of the Bbmp. The detailed orders have been passed, taking into consideration various judgments of the Supreme Court. Now, in fact, my lord, the government pleaded its inability to demolish those structures because they did not have the wherewithal and the required staff. Then the this honorable court directed them to make recruitment. That's how, my lord, the Public Service Commission was made as a party. I don't know what stage the recruitment process is.
And for respondent number 5, my lords, in 25 point.
To appear for whom?
Commission,
Besco.
regulatory commission, my lord, electricity regulatory, KERC.
They simply wanted to sell power, irrespective of the fact whether the building did have the license.
You're supporting this regulation.
Lord,
You're supporting this regulation.
Lord, it is my regulation which permits, my lord.
We'll hear on the
Yes.
one day and.
My lords, I would like.
Lord, your lordship may
I
have
think
to.
the circle is complete after this direction.
No, my lord, I understand, my lord.
Is complete.
Your lordship may kindly ascertain from the government as to what the recruitment process,
Please,
what
madam.
stage it is.
And for the.
That's
case-
because
Recruitment
to various posts of engineers in Bbmp, that is the municipality, which is required to carry out demolition.
Exams.
They pleaded ignorance or inability because they didn't have the required staff.
So
And-
25, my lords, the mayor, 25 is in relation to the KERC notification which we have challenged. 25.1, which is the suo motu petition, my learned friend is acting as amicus there. So you suppose ask by the council.
I'm supporting him, in fact.
Of course. My lords, therefore. in
Or rather, you
20
are supporting me.
In 25.1, my lords, if I may make one submission, my lords. In 25.1, if I make one submission.
Are your individual houses and flats according to bylaws?
No, my lord.
It's
They were
not.
supposed, there are as
No,
many.
no, I'm asking your individual houses and flats. Whatever that you are living in.
No, we don't fight shy to submit. They are all in order.
My lords, in
After
25.
all, I'm an amicus. I don't think the court would be interested in knowing my.
No, in a lighter way.
No, I understand, my lord, but there is absolutely nothing about it. But there are 3 reports before this honorable court submitted by the Bbmp itself, showing large scale violation. They express their inability because they don't have the number of staff to carry out the demolition.
My lords, and for the
Big buildings will
KPSC, my
go.
lords,
There,
has.
on a 30-feet road, there is a structure of 11 floors, which is contrary to what FAR permissible.
One more submission, my lords, in the suo motu petition 25.1. This honorable court, my lords, on the administrative side, had passed a circular of 11/1/24 directing, stating that in respect of illegal construction issues, the civil court should not exercise jurisdiction. And passing that circular, my lords. What we have now found is, despite this circular, there are a number of cases that are pending in which Bbmp is made a party and stays are being given in connection with such illegal construction. I request, my lords, if your lords could direct the registry to obtain details of this, because there is a direction of this honorable court.
Let us fix the matter and hear it on.
Yes.
Yes.
It will be, then we'll all able to give all direction.
On one day, my lord, in the afternoon, subject to your.
In the
I
afternoon.
would like to make a submission, my lords. I was impleaded by the order dated 23/24, my lords, KPSC, as to why the exams were not conducted with regard to the recruitment of assistant engineers, my lords. As on 18th, 19th, and 31st of January, exams have been completed, my lords. As of now, the verification of documents have been going on. So we've completed our purpose, my lords, as of 18th, 19th, and 31st of January 2025. So we're not the necessary parties anymore, my lords, because we were impleaded only as per the recruitment process as to why the exams were not being conducted.
That we'll see on the day of
Please, my lords.
20th March. Bless you. At
Can I
2:30.
request it? Subject to my alert friends convenience, either 21st, 20th, I'm not in town.
20,
Any day, any, before or after.
21st Friday. Let us say 21st per time. 21st.
Much obliged.
20.
Grateful.
Your role will be over only after this.
Number 26. So Pawan Chandrasekhar.
Very short point is involved, my lord. The subject matter of the property, my lord, which I got, my lord, from the competent authority regarding, my lord, acquiring the M sand. After the license, my lord, the authority is saying, my lord, the distance of existing land which has been allotted by the state government is, my lord, comes within 1 kilometer, and another authority is saying, my lord, it is after the 1 kilometer. That is the only dispute, my lord. Now, your lordship may kindly peruse, my lord, running page number 209, annexure K. Volume 2, my lord. 209, annexure K. May I read, my lord?
My lord, please see the prayers, my lord.
Lord, one authority is saying, my lord, this property, the land allocated which is for quarrying is within the 1 kilometer, and another two authorities, major authorities, my lord, saying it is after the 1 kilometer. Now, your lordship may kindly come to annexure K, my lord, page number 209. 209. My lord, this is general license form issued on dated, my lord, 30th April 2016. Under the, my lord, single window task force committee, that is, my lord, respond number 9, who has, my lord, senior geologist Bangalore Urban, who has given issued license. The license speaks about, my lord, sanction is hereby accorded for grant of quarrying lease for building stone / manufacturing M sand mineral for a period of 20 years to measures Sri Rama earth movers over an extent of 1 acre 20 gunta of land, 23 survey number 23, Tamanayakanhalli village, Anekal Taluk, Bangalore, urban district. Now, your lordship may kindly come to my lord. Annexure P, my lord, page number 237. My lord. This is, my lord, form number C, license for stone crusher. The license for establishment of for a 1000 HP stone crusher in favor of Sri Rama Transport and Sri Rama Earth Movers for M sand over an extent of 1.32 acres in survey number 243/1 Patta land of Tamanayakanhalli village, Anekal Taluk, Bangalore urban district is accorded to deemed extended for a period of 20 years from the original grant date 6/9/2017. The license should be strictly adhere to relevant act and rules. This license is valid up to 31/3/2037. That is on dated, my lord, by the issued by the respond number 6, who is the, my lord, Deputy Commissioner and Chairman, District Stone Crusher Licensing and Regulatory Authority, Bangalore Urban District. Now, your lordship may kindly come back to my lord, Annexure H. Running page number 201, my lord. Very next page, my lord. This is regarding the, my lord, inspection report of applied area for acquiring lease and license, my lord. The observation which has been made by the competent authority, running page number 202, bottom para, my lord. 202. Running page number 202, my lord. Bottom para.
So some survey was carried out
Yes, ma'am.
My lord,
and it
comes
is found
within
within the forest.
zone and it is covered by the decision of my lords. My lord, I have produced it as annexure R8,
My lord,
my statement of objections,
lord,
my lord's order.
that is, my
On
lord,
page 152.
that is, my lord, if it is comes under within 1 kilometer.
It is in the eco-sensitive zone.
My allotted property is not within 1 kilometer. It is after the 1 kilometer. That is the competent respondent authority, that is the state authority, has given the opinion saying that
This is confirmed.
Yes, my lord. And my
That-
lord, and the forest department has not given them the NOC.
that is what? That is what I am before this honorable court, contrary to by one government and another department to another department.
No, that is because you took the
So,
office
mine
and
and
you got
geology-
that inspection
No,
report.
that is, my lord, that if state authorities, my lord, contrary to between themselves, my lord, it is the hurdles for the, my lord, innocent petitioners. That is my humble submission, my lord. My lord, may kindly see the annexure H, running page number 201. Running page number 201, my lord. Annexure H, my lord.
All the three authorities should give you the NOC.
201, yes.
Yes, ma'am.
No, some inspection report.
Yes, ma'am. Inspection report, applied area for acquiring lease and license /license.
very next page, my lord, bottom para. That is the right side, there is a column, my lord. May I read, my lord? Column after the photo, my lord, Google map. The senior geologist and assistant commissioner Bangalore South in their joint inspection report dated 26/8/2015 and NOC letter wide so and so dated 26/9/2015 have recommended to issue NOC to the applicant as there are no villages, national highways, railway lines, memorials, and revisors within the 200 meters from the applied area, and accordingly NOC has been issued. The Assistant Conservative Forest, Bangalore South Division, in his letter wide 5/8/2015 has opined that applied area is located away at a distance of 1.2 kilometer from the Mahadeshwara Protected Forest, which is a part of Bannerghatta National Park. Now my learned friend is saying, my lord, the forest authority has not given. Forest authority, everyone has, my lord, went to the spot, made a joint inspection. This is this forest authority, my lord, after giving their, my lord, consent, then only, my lord, this competent authority.
Located away at the distance of outside the.
Yes, my lord, outside. Now your lordship may kindly see that, come to, my lord, annexure J2.
Which report says that it is inside?
My lord, I will come, my lord. That is annexure V, my lord. Annexure V.
Page.
Yes, ma'am. Annexure V, that is Department of, my lord, sixth respondent, my lord, that is Wildlife Authority. Page 329. So two authorities are saying, my lord, it is after the 1 kilometer. But only one authority is, my lord, disturbing. 329, my lord. Annexure V.
That is in vernacular.
Yes, my lord. English, my lord, 332.
332.
Operative portion, my lord, your lordship may kindly see that. 333. Identical. With reference to the above subject, as per reference 1 and 2 above, on 17/12/2021, the Forest Department, Department of Mines and Geology, and Revenue Department has jointly surveyed 4 acre 25 gunta acre out of 1.2 acres of land situated in survey number 23 of Tammanayakanhalli village, Anekal Taluk, Bangalore Urban District, notified for building stone quarrying lease in favor of Sri Rama Earth Movers, and the said area comes within 1 kilometer range of eco-sensitive zone of Bannerghatta National Park. Further, even though the 1 month period has lapsed since conduct of the joint survey, the sketch marked in the village map is not yet submitted. Therefore, it is hereby requested that the village map prepared by conducting a joint survey may kindly be submitted to this office at the very earliest. The sketch prepared on Google Earth and the photographs taken at the time of joint survey are enclosed herewith.
Why is it discrepancy?
Yes, ma'am.
My lord, please take my statement of objections, my lord. They are in detail.
Then one more, ma'am.
Yes, paragraph 4.
Identical circumstance for 2 of them, my lord, very next adjacent property, they got the license.
That will, yes, where is your statement of objection?
My lord, it's dated
Yes, 18/7.
18. My lord, before that, if my lord could take paragraph 8 of the written of the petition, my lord.
You have to
Paragraph 8, internal page 14.
reconcile this discrepancy. Yes, paragraph 8.
8. My lord, the second sentence, paragraph 14. Writ petition. My lord, the sentence, it would be appropriate. My lord, I take it as the petitioner has accompanied the senior geologist because this is the meaning that this sentence conveys. It would be appropriate to mention here that with the assistance of a senior geologist, mines and minerals, a sketch dated 4/12/2014 towards identifying the land measuring 2 acres were drawn. and annexed along with the application form, along with other documents as sought for by the concerned authorities. What this sentence conveys is, my lord, the petitioner has accompanied and got this done. That is the meaning it conveys. My lord, this is how I read it. Then my lord may take paragraph 12 of the petition, where he himself admits, my lord, however, in the course of setting up of his unit, it came as a rude shock and surprise to the petitioner when out of the blue, that is subsequent to the notification dated 30/10/2018, wherein it became mandatory that the petitioner was required to also obtain an NOC from the Bannerghatta National Park prior to him commencing any quarrying or crushing activities. That is because, my lord, the land in question is situated in an eco-sensitive zone. He is aware of that. And my lord may take, my lord, the next, my lord, 12(2), the senior geologist, paragraph 18. My lord, there it says, the senior geologist, Mines and Minerals Department, after a long gap of 4 years. My lord gets it. From the date of issuance of the license in bearing of the petitioner, had made out a letter dated 30/11/2021 to the Deputy Conservator. My lord gets it. Of Forest, Bannerghatta National Park, Anikal Taluk, Bangalore, seeking clarification if land in survey number 23, my lord, so and so, and more specifically, which was given to license the petitioner, fell within the eco-sensitive zone, that is 1 kilometer from the Bannerghatta National Forest Reserve. As a result of the aforementioned communication, the Deputy Conservator of Forest, Bannerghatta National Park, Anikal Taluk, Bangalore Urban District, held a spot inspection and got reduced the land from 5 acres to 4.25 acres. My lord, most importantly, what I want to submit along with these paragraphs is that there is no application for seeking for quarrying in respect of survey number 80. Now, my lord may take paragraph 4 of my
Survey number-
statement of objection.
Survey number 23,
Yes, ma'am.
not 80.
My lord, paragraph 4 of my statement of objections. My lord, please take before that annexure B, that is at page 332. My lord, this is from the office of the Forest Range Officer to the senior.
Reserve. My lord, you applied for reserve. You have applied for reserve.
I have, yes, my lord, annexure T. Made a representation.
Where is page? Annexure D.
Yes, ma'am. Running page number 279.
270.
I have given, all representation has marked, my lord.
My lord, even otherwise, he hasn't complied with the terms and conditions of, my lord, the notification that is issued. That is my second submission to my lord.
Then when I.
The conditions,
When,
he hasn't installed.
when,
He's not, the crusher unit, he hasn't installed. My lord may take paragraph 5 of my statement of objections, very nicely drafted, my lord, by my colleague, Mr. Mahender. I have to give credit to him for that. I'm magnanimous, my lord.
So that in the next case, he should not ask for any prayers.
Very
Oh,
true.
no, be fair. I wouldn't want to do that. I'm fair, my lord. I don't.
Lord, if it is for joint survey, my lord, this is also.
No, no, no.
ultimately
President
that
of
is, my
joint
lord,
survey doesn't
no,
come, my
because
lord.
one
Please
authority
see
is
the,
contrary to another authority.
Paragraph 5.
yes.
This matter was argued earlier.
Yes, it was
Yes,
heard. And my
argued.
lord wanted to, my lord had referred to the prayers and found that such prayers couldn't be granted. I didn't want to make that submission. That's the reason why I brought it to the attention of my lord.
Oh, my lord. I'm sorry, my lord. No such observation, my lord.
You ears are also sharp.
I'm only on the, my lord, merits of the case, man. For resurvey, my lord, I have made my representation to the competent authority, that is Annexure T, my lord. Wherein it is, my lord, I have requested the authority themselves, since, my lord, there is a lot of, my lord, difference between the Mines and Geology District Task Force Committee, that is DC of the Bangalore Urban, then Forest Department, then Wildlife Department. Now, my lord, only Wildlife Department people are troubling us. None other Revenue Department, Task Force Department, and all competent authority, that is including Mines and Geologists, my lord, they have stated that it is away from 1 kilometer. Except, my lord, this authority, Annexure V, which has been passed.
J&K have not been
Actually,
complied with.
Wildlife Authority does not have any locus, my lord, to give this such a report. Wildlife Authority, my lord, is given contrary to the Forest Department. That is what, my lord, I have
But
made.
we are concerned with the survey number 23.
23.
And
There, in respect of that, you are supposed to, number one, comply with the conditions of the grant.
yes,
Number two, the notification of the eco-sensitive zone treats the survey number within the.
Yes.
yes.
What is now, what is the difficulty now?
Now, my lord, if they will give the, my lord, proper survey with respect to the, my lord,
By
where,
notification,
my lord,
we'll go by notification. It is
Yes.
not under challenge.
my lord, no, my lord, there is. Before this one.
5/5/22.
I
Yes,
don't
my
want
lord,
to
state
see
is
it.
very much wrong. That is what. I'm very serious about the, how there such a wrong statement has been made before this honorable court. In identical circumstance, my lord, they have observed that very identical survey number which is away from 1 kilometer. That is what I want to relay before this honorable court. Your lordship may kindly see that. For 2 persons, inclined people, my lord, they are able to get 9. That is wrong report, wrong draft, my lord.
My lord, my paragraph 8 of the statement of objections is
State
very
is, my lord,
clear.
very clear.
Then
very-
he should have filed a rejoinder. I would have met that.
This is a wrong statement as brought before the honorable court. Tamanayakanalli, survey number 23 is, my lord, away from the, my lord, eco-sensitive zone. That is the, my lord, subsequent order of the authority. That is contrary to the, my lord, statement of objection. If need, my lord, I will file a rejoinder, my lord. I have already obtained the copy. I have obtained the copy. State need, my lord, then I will file a rejoinder. My lord.
So 5/5/22 notification is at page
That is for not for this.
187.
Yes, my lord. Not for this. Not for this survey number. That is wrong information given by them. It is in, my lord, vernacular language. What it is saying, my lord, antaradalli ide. May I permitted to read, my lord? It is in Kannada. May I read, my lord? It is in Kannada. ಸದರಿ ಕಟ್ಟಡ ಕಲ್ಲುಗಣಿ ಗುತ್ತಿಗೆ ಮಂಜೂರಾತಿಗೆ ಕೋರಿರುವ ಪ್ರದೇಶವು ಬನ್ನೇರುಘಟ್ಟ ರಾಷ್ಟ್ರೀಯ ಉದ್ಯಾನವನ ಹಾಗೂ ಪರಿಸರ ಸೂಕ್ಷ್ಮ ವಲಯ, ದಟ್ ಇಸ್ ಮೈ ಇಕೋ ಸೆನ್ಸಿಟಿವ್ ವಲಯದ 1 ಕಿಲೋಮೀಟರ್ ಮತ್ತು ಮೀಸಲು ಅರಣ್ಯ ಪ್ರದೇಶದ ಪರಿಭಾವಿತ ಡೀಮ್ಡ್ ಅರಣ್ಯ ವ್ಯಾಪ್ತಿಗಳಲ್ಲಿ ಬರುತ್ತಿದೆಯೇ ಅಥವಾ ಇಲ್ಲವೋ ಎಂಬುದರ ಬಗ್ಗೆ ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ನೋಡಲಾಗಿ ಸದರಿ ಪ್ರದೇಶವು ಬನ್ನೇರುಘಟ್ಟ ರಾಷ್ಟ್ರೀಯ ಉದ್ಯಾನವನ ಹಾಗೂ ಪರಿಸರ ಸೂಕ್ಷ್ಮ ವಲಯದ 1 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವುದಿಲ್ಲ. It is not comes under within the 1 kilometer from the eco-sensitive zone. That is how the, my lord, the findings has been given by the authority. That is ಬನ್ನೇರ್ಘಟ್ಟ ರಾಷ್ಟ್ರೀಯ ಉದ್ಯಾನವನ ಬನ್ನೇರ್ಘಟ್ಟ, ಬ್ಯಾಂಗ್ಳೂರು.
We made some clarity.
I will clarify it. Ma'am.
If it is comes under eco-sensitive zone, then I don't have case. If it is comes within the eco-sensitive zone, then I don't have any. say
My
to
lord,
before,
even
my lord.
otherwise, my lord, the notification, my lord may see which my learned friend has read J and K. Those conditions have not been complied with.
It is notified to be deemed forest.
No.
Yes, that's why it is produced
No,
before.
It appears to be so.
My lord, even as per the judgment of my law, this honorable court, there is no deemed forest in the state of Karnataka.
No.
That is what, my lord, yes. There are two
This-
judgments by this honorable
My lord,
court.
this is given and it is submitted to the Supreme Court also.
That is, my lord, I am also, I have
Proceedings
a
of
chance
the-
before the honorable Supreme Court in Godavarman case. The state government has, my lord, made a false affidavit before the honorable Supreme Court.
Lord, let
Contrary
him
to-
not harp saying that we.
Contrary to
false
the judgment of this honorable
submissions and
court.
all that.
Then I will bring, my lord, that judgment. It is me only. I am now before honorable Supreme Court.
All of us are making false submission, you are making correct submissions.
That is the contrary to the judgment
is
of this honorable court, my lord. They have filed affidavit before Supreme Court. This Lordship Justice Oka and my lord, the Suraj Govindaraj has made an observation. It's a reported judgment. There is no deemed forest in the state of Karnataka.
My lord, even otherwise, my lord may take a paragraph.
No question, even
it's
otherwise.
all right.
This is the fact. This is
My
the
lord,
truth.
please take paragraphs 4 and 5 and 6 of my statement of objection. Even on that ground, his writ petition has to be dismissed. If my lord were not to go into the eco-sensitive zone,
Right.
conditions are not satisfied.
We'll have some clarity, but that ground is good enough.
Please,
Paragraph 5.
I'll clarify it. ma'am.
let them clarify. Please, I will wait, my lord. I'm waiting before them from 2017.
No, it is the onus on you to clarify.
My lord,
You are the petition.
I'm tired before the authority, my lord. That's what I'm ultimately I knock at the door of this honorable court. Otherwise, I don't want to come to the honorable court
Why?
because we are before them like
But he
anything, my
hasn't
lord, for
given
that
the
survey,
pleasure
this
of
survey,
appearing
contrary
before
to
my
the
lord.
survey.
That's the reason
So
why
many exercises, my
I
lord,
will-
we did, my lord. Nothing have if one authority is saying better position and another authority is remarking the same.
But you don't want to come to the court.
No.
Why?
Ultimately, last resort, my lord. Please, my lord.
If the context is there, then good. Otherwise, the context
Yes.
is different, then.
My lord, I have
Some
sought
reason-
interim
You
order.
have some serious reservation.
Yes, ma'am. I have sought
Like-
some, I am sought some, my lord, interim order, my lord, because,
It is already there or then it is there?
no,
We'll get it.
because huge amount I have spent
We'll just go through.
for the generator, my lord, the lorry,
This also
crusher
will
unit.
complete. Because lot of time is devoted. 11th March to be listed at 2/3.
Please,
Obliged.
very grateful, my lord, deeply obliged.
Number 27, Sundar Raman.
For the petitioners in this case, my lord. My lord, I
Hello,
have
sir. I
filed,
am respondent number 2 and 3 in this matter, my lord.
my lord, we filed this current public
My lord,
interest petition.
my lord, this petition is infructuous, my lord.
Yes.
My lord, the construction is over and the traffic movement is free. That is my instruction now, my lord.
My lords, may I be permitted to file a memo before this honorable court?
Withdrawing. Memo of withdrawal.
My lord, My lords, this memo, along with the memo, I have produced photographs, my lords. Recent photographs of pedestrians having to cross railway lines as the underpass construction is not complete, my lords.
Oh. Now the bill is saying that it is completed.
My lords, honors could kindly look at page number 7. my
Problem,
lord.
but mandamus restraining the respondents from carrying out demolition.
My lords, we are only pressing for a foot overbridge to be
We are
constructed
poor.
in this matter.
Until reopening of the alternate. Now this alternate road is ready? Who appears?
My lord, I appear. My lord, the petitioner, my lord, I had taken the contention, my lord, the reason why we were deviating the traffic because of the construction by the railways. My lord, now the petitioner who's reciting there says that the construction is complete
My lords, we
and
are-
there is free flow of traffic. But this memo is dated, I think, 4th July 2024, corrected to 12/2/2025. So the photographs may be old.
My lords, as it stands, my instructions are that the construction is not fully complete. It is also our case that pedestrians are now having to cross railway lines. Because even the alternate foot over bridge, my lords, even the alternate underpass is still under construction.
Who is for number one? For number one?
I am for the BP, first respondent.
And who is for number two?
2 and 3 is the Reshma.
I am for the respondent number 2 and 3, my lords.
Have you put the completion
I
aspect?
filed my statement of objection, my lords.
Where is it?
Recent pictures, it is there, my lords.
No, the latest development about the completion of the work.
I have received the instruction yesterday, my lords. I will file that. my
Put
lords.
on record.
Please, my lords.
By learned advocate Ms. Rehana
Reshma.
Reshma for respond to states that the construction work of railways.
Railways.
Please.
Railways.
Is over, she would file affidavit in that regard before the next date put up on 17th March. 17th March,
Public.
Reshma, lords.
the petition may be listed at 2:30 regard to the scope of controversy noticed in course of the hearing today.
Obliged, my lords.
Memo is filed by learned memo dated. Memo is filed by learned
Next week, status.
producing photographs which is taken.
May make one submission, my lord. Serial number 33, my lord, I have filed application for recalling the order. But I may permitted to comply the office objections, my lord. Unless it is complied, I can't argue.
My lord, there is a delay of 565 days in filing the recalling application.
Serial number 53,
33, my lord.
33.
33, my lord. I may permitted to comply the office. It is ready, my lord. It is voluminous. I have given for translation and other things, my lord.
What is
Therefore, my lord.
PA?
PL, my lord.
Recalling.
Recalling dismiss for default for non-compliance for non-filing, my lord. I may permitted to comply there.
Be complied within 2 weeks.
Yes, madam.
Failing with the petition shall be dismissed, shall stand dismissed without reference to our order.
With your lordships kindly. Yes, filed recalling application.
Recalling, what is the objection?
My lord, I may permitted to comply the office objection, my lord. Please. I may,
We'll take up today itself.
my lord, voluminous, everything is ready, my lord. I have to comply the office objection.
No,
Unless I comply the office objections, my lord.
we'll dismiss with all office objections.
Right.
Dispense with all office
It is,
objections. 3rd March.
in the meanwhile, I may permitted to comply the office objection.
3rd March.
With your lordships kindly. Serial number 31, there is some urgency, my lord.
31 will reach. Why? It will reach. Definitely reach.
Serial number 61, madam.
61.
I have filed wakalat for R9. My name has not been shown.
We'll write down your name.
My lord, serial number
And,
28.
For reply for 2 weeks,
2 weeks.
My lord,
2 in 4 weeks.
4 weeks.
My lord, it's only a
No, this is
manifest-
PIL, no for.
Yes,
No,
PI.
no time, no time. PIL is very dear to us.
Serial number,
My lord, serial number 28.
Hmm?
I appear for respondent number 13 in this matter.
Which
They're
one?
led by a senior counsel, my lord, in
Which-
serial number
Serial number
28.
28, that's the next matter.
But I appear for petitioner. This is a case where, my lords, the cow slaughterhouse is started within the prohibited distance of Kalburgi Airport. Lordships have examined this, and now, my lords, the pollution, there is no permission from the DGCI, which was one of the conditions for closure order.
For whom?
For respondent number 13.
He is running the slaughter. He is running the slaughter industry.
I am for DGCA, the.
There is no
Exam
permission, my
simulation.
lords.
Give
And
time.
our instructions are that there is no
Permission.
permission that we have.
Or if there is no permission, they have to stop operations because they are culling out around 500 cows per day.
I'll file my detailed objection.
They can't reverse it, my lords.
That's my habit next week. I appear for Pollution Control Board in this matter.
3rd March.
But that, your lordship may
Next week, my lords.
earlier, my lords. Undisputed fact that the cows are getting slaughtered, my lords, without their being a
20th
permission.
February. 20th February.
Grateful minutes.
serial number 36.
28.
28.
28, very.
20.
2-0, there is some.
That's
Some difficult.
Enjoy.
2-8.
Then 3rd March is okay.
Third, yeah, 2-8, my lord,
My lords have indicated.
3rd
2-8
March is
or-
okay.
3rd March.
3rd March.
That's
Serial number 36,
60.
my lord. My lord, serial number 36, my lord.
I appear
2
for the,
weeks time may be granted, my. 2
I
weeks time may be granted, my.
Serial number
Granted.
46, my lord.
The 3 weeks. All right.
Serial number 46 also, my lord. 2 weeks time in again. Filing reply.
Serial number 41, my lord. Serial number 41, I am filing memo, my lord. The accused has complied the order, my
Serial number-
contempt petition.
Serial number
41.
41.
41, my lord.
Learned reviewer, Mr. Nagesh.
Nagesh.
Learned reviewer Nagesh files a memo dated 12/2/25 stating that the respondent has complied with the directions in the order of learned single judge passed in writ petition number 7970/2022 by effecting Kodi and Durast in respect of the property in question. Full stop. The memo is taken on record. As requested in the memo paragraph, the proceedings, contempt proceedings are dropped in view of the compliance. The affidavit of compliance filed by the respondent is also taken on record.
Please.
Kindly. Morning I mentioned about that. I was told by the court.
We have indicated
But
19.
But my lord, there's an
9.
emergency because day after tomorrow, the learned magistrate is passing an order for delivering possession, my lord. 14, the order we got. That is, the entire thing is done behind our back. They moved an application to section 14 before the learned magistrate and say, seeking protection and possible possession, my lord.
14th of
14, that's the day after tomorrow, my lord. My lord can have it tomorrow morning, my lord. Because it entire, be frustrated, there'll be a multiplicity of proceedings with third parties. And there's a specific direction I was told.
Is
in
it a-
another writ petition, my lord, where government has been directed by a single judge to take possession. Their undertaking was given by the AG, I was told. Take
is
possession.
it
of-
PAL? PAL.
This is a PIL, my lord. This is from 2012 onwards. There's a violation of an order passed by this honorable court. From 96 people, 1,500 families are living in the street. You can mention it.
So, 17th is our case. We construct instead of constructing one Bbmp was, we constructed into a PPP module and with the private fund, wherein one was returns of Bbmp and both of was given to private individual. The private individual went and mortgaged it with financial institution, borrowed the money and committed it. But financial institution tends to close the market against them and the entire property in its entirety is not going out of Bbmp cases. That is anti-RT proceedings and surface proceedings have been initiated. The past surface order and this is 14. Section 14 order. Section 14 order that magistrate, which is no dispute. No dispute. As a ministry of
In fact, we have no right of audience before the learned magistrate and standard section 14 also.
Only 2 more.
Much obliged.
Yes, serial number 46, my lord. Permission, the serial number 46, my lord, I pray for 2 weeks time, my lord. I informed the other side also.
At the request of learned reviewer, the petitioner stand out 26th of March.
This much.
The PIL. For days.
Pass over matter, seal number 1.
Srimati Navyasri R. Rao, party in person.
Party in person, learned party in person, appearing. Learned petitioner, there's learned party in person is present, was not present in the first session. When the petition was called out, she was again absent in the second session. The contempt petition is listed at serial number 1 in the board paragraph. However, in the larger interest of the, to be listed next one. March 10th.
230 matters. Serial number 79 to SV Butt.
For the accused. Petitioner in this case,
Why it is kept at
complainant.
contempt?
The order, your lordship will get it at page number, starts at page number 16. The relevant paragraph at page number 25, para 14 and para 16 at page number 26. Any of them petitioner is entitled for compensation payable as determined in the award as per at annexure F, more particularly as per paragraph number 10 of the said award, proportionate to the extent of the land which the petitioner is entitled to. Then 16, though the petitioner has already given representation as per annexure G, to avoid further confusion, the petitioner shall file a fresh representation with all supporting documents in respect of the entitlement before the respondent number 2 within 4 weeks from the date of receipt of the certified copy of the order. Thereafter, the second respondent shall pay the balance amount in terms of the award produced at annexure F within 8 weeks from the date of the receipt of the certified copy of the award order. But accordingly, on 9/11/2023 itself, I was sent the representation along with the certified copy of the order also. Then again on 17/1/2024, I have issued a notice calling upon them that they have not acted upon the as per the award order. The same has been received on 18/1.
Yes, please, my lords. My lords, I am representing the accused, which is the acquisition, which is the competent authority constituted under the National Highways Act. When we just went and sought for the implementation of that particular order as passed by the learned single judge, we were informed by placing reliance of a single judge judgment of this honorable court, stating that there is no power conferred upon us to pass supplementary award. And assailing that award passed by us, the project implementation unit, that is the project director, has filed an appeal before the jurisdictional deputy commissioner. That appeal memorandum also I filed it along with the statement of objections, my lords. So pending disposal of that particular appeal, they are not letting us to comply.
So where is annexure F? Where
It's
is
in the writ
award?
petition.
Where is the award?
Please,
page? It is produced.
Annexure A, Miller, page number 12.
Page
The relevant item insofar as petitioners are concerned, complainant are concerned, at page number 14, para 10, second paragraph, para 10. As per RTC survey number 41 and 42, the total area available is 3 acres 27 quota. Out of this, an extent of 1,267 square meters has been acquired. The award is fixed.
Where you are reading?
Page number 14, my lord.
Page 14, para 10.
Page 14, my lord, para 10.
It is a table. Page 14 is a table.
I'm sorry, then page 14, 15 minutes.
15, yes.
Para 10 million.
Para 10. No.
As per RTC, survey number
10
40.
is not there. Some mistake in the paging. Petition. Petition.
Along with the petition, my lord, it is in the beginning of the petition, my lord. Sorry.
Where is the petition?
Perhaps my lord has the copy of the objection statement. It is in the beginning, my lord. Immediately after the order of the, immediately after the petition, it is mentioned.
Or it's there in my objection statements, my lord. I filed it along with my objection statement.
Page 14, my lord, para 10. As per RTC survey number 41 and 41/2, the total area available is 3 acres 27 guntas. Out of this, an extent 1,267 square meter has been acquired. The award is fixed at NAK rest roadside.
3 crore 45 lakhs.
Yes, my lord. 3 crore 45 lakhs 38,906.
Is it?
In that, my lord, my extent, my lord, your lordship would get it at page number 13. Mine is only, my lord, it is about 357 square meters. My lord.
What is
It
your?
is only that, that proportionate amount only the court has ordered. It is not the entire amount.
What is the proportion? It is.
The proportionate amount, my lord, I have calculated, my lord, at page number, in my notice dated 9/11/2023, my lord,
29 lakhs?
89 lakhs 85,836 is the amount payable, my lord.
89, 85, 836.
Yes, my lord.
Is it quantified anywhere? At which-
My lord, that is, my lord, quantified in para 10 itself, my lord. The total amount is 3 crores 47 lakh 38,906, my lord. If it is calculated, my lord, it comes to about per square meter 27,000 and odd, my lord, per square meter. The calculation, I have not produced the calculation, my lord. I'm
Doesn't
sorry.
matter.
I beg your pardon.
So your land is which? 41-1, 41-2?
Yes, my lord. It comes in 41-1, 41/1.
Part
About
of.
part of it, my lord. Only 367 square meters is the total extent that is acquired mine, my lord. 324 square meters. Lord, your lordship will get it, the notice, my lord. In the notice I have mentioned 17/1/2024. The total amount that is balance amount payable to me is about 64 lakh 95,730. Lord, they have given about 23 lakh 66,510. Balance is 64 lakh 95,730 as per the award, plus interest from the date of the revised award dated 10/1/2020, million.
Notice at page 31.
Yes, my lord. 17/1/2024 is the
Correct,
notice.
17.
Paragraph number 2, my lord, in that. First paragraph, I have stated how much the total amount, and then, my lord, out of which an amount of which 23 lakh 66,510 has been paid as per the voucher dated 17/12/2021. Thereafter, my client has demanded you to pay the balance amount of 64 lakh 95,730 plus interest at 15% on the said amount from the date of the revised award dated 10/1/2020 till 2/3/2023, while letter dated 2/3/2023. As the same has not been paid, he has filed the writ petition reference to before the Honorable High Court of Karnataka against you, arranged as a respondent number 2, and the Honorable High Court, while order dated 3/10/2023, has been pleased to dispose of the writ petition, specifically holding in paragraph number 14 that in that view of the matter, the petition is entitled for compensation payable as determined in the award at Annexure F. More particularly, as per paragraph number 10 of the said award, proportionate to the extent of the land which the petitioner is entitled to, and in paragraph number 16, directed my client to file.
Now, what is the problem with you in paying the amount?
Please, my lords.
What is your problem in paying the amount?
Please, my lords, the reason is there is a blunder that has been committed by the accused authority. There is a blunder that has been committed by the accused authority. In this instant case, what had happened was in the year 2019, they passed one award with regarding awarding compensation for the complainant herein. Then subsequently in 2020, they passed a supplementary award. In terms of the act under section 3G, There is no power that has been conferred upon the authorities to pass a supplementary award.
File appeal against this order.
Assailing, but I was not a party in that case. So the appeal has been filed by the project implementation authority. If my lordship could look into page 4.
So no appeal is filed against this order.
This order, since there is, I am just going, the project implementation unit, that is the project director, they have filed an appeal before the.
Respondent number 2, who is respondent number 2?
Respondent number 2 is myself, my lords. That is the
Yes,
special land acquisition officer.
correct. Who is that? Srimati K. Manorama,
Yes, Pillar.
the special land acquisition officer and competent authority, Nila Mangala, Tumkur National Highway 48 into old NH-4.
My lords, one submission, my lords.
My town shall personally remain present before the court. On
One
which date?
submission, my lords.
On which date she will remain present?
One
This is
submission, my lords.
blatant disregard of the court's order. Are you going to pay as per the award or not?
I shall, my lords may just give me 1 week's accommodation, my lords. I shall seek necessary instruction, my lords.
No instructions. You pay. That's the only instruction.
One submissions, may I just pass on this one particular judgment, my lords?
No, we don't see any judgment unless it is come to contempt is purged. This is not the writ petition where you can contend on the merits of the order.
Please, my lords, but however, my lords, my hands are tied.
Our hands are
My hands are,
our hands are handcuffed in this
Please, my lord.
jurisdiction.
One submission, one respectful, no,
What
one
do you-
respectful submission, one
We are not
respect.
interested in any further debate. Are you calling the officer or complying the officer? What do you want? Only 2 options. Third options, you know.
I shall impress upon them 1 week's time.
No, weeks time will give, but comply with. Otherwise, the officer.
I'll seek instructions, sir. Week's accommodation may kindly be granted, my lords.
No.
Week's accommodation may kindly be granted, my lords.
Accommodation will give, but for compliance, not for taking instructions.
I shall seek instructions, my lords.
No. Then let him remain present. On which date?
Sometime the presence, I shall just come, I shall see, all that I'm saying is, now without seeking necessary instructions, and that particular officer is no longer in service.
We do
She's
not-
been retired, my lords.
Sir is in service, we will call him. And straightway sent to the jail from here on. If you're not paying the
Because
compensation of the
due to the erroneous interpretation of law,
We are
they have
not-
just passed a supplementary award.
Counsel, we are not interested in debate on merits. This is a contempt jurisdiction. If you don't know, you must know. So what do you propose now? Option is 2, third option you know. Tell us.
I'll just use my good officers in convincing them to comply with that
Very
order,
well.
my lords.
Very well.
It's just,
So we'll-
it may not be taken as my undertaking, my lords.
We'll-
It may not be taken as my undertaking, my lords.
So
2
nobody
weeks
under-
accommodation, 2 weeks accommodation may kindly get. Using my personal good offices, I'll try impressing upon the officers,
no.
my lords.
We don't know using of good offices. We want only compliance. Under the directions of the learned single judge passed in order dated 3rd October 23, while disposing of the writ petition, respondent number 2, special land acquisition officer and competent authority, Nelamangala Tumkur National Highway 48 is required to pay the balance amount of compensation pursuant to the award under the Land Acquisition Act to the petitioner. Post of the petitioner has already issued notice dated 17/1/24, seeking compliance and requesting the payment of balance amount of 64,95,730 plus interest at 15%, which flows as entitlement of the petitioner from the award dated 10 and 10/1/2020, passed by respondent 2. Full stop. Learned advocate for the respondent number 2, Mr. So-and-so, prays for time. Full stop. Time is granted up to third of March. It is expected that on that day, the contempt shall be purged and the compliance will be reported, failing which the court may be compelled to take a serious view on the conduct on part of the respondent in not complying with the directions of the court. The contempt petitions will be listed at 2:30.
Please.
Case number 80, to Vijay Kumar K.
Remember?
Appear for the complainant in this matter, my lord.
Yes, Mr.
The accused are supposed to execute 7 sale deeds in my favor, my lord. They have complied partially and they have executed 2 sale deeds in respect of 2 sites. And I am agreeable to get sale deed in respect of other 5 sites which the accused has submitted by way of a memo on the previous date of hearing. They are agreeable to obtain sale deed in respect of these alternate sites. And in respect of 2 sites, they have yesterday executed 2 sale deeds they have executed.
You filed some
Lord,
complaint.
so the learned single judge has directed us to execute the sale deed for 7 sites. For the 7 sites, my lord, 2 sites, 5 sites were not part of the sanction plan. So instead of those 5 sites, we have proposed alternate sites. We filed the allotment letter on the last date of hearing, my lords.
Then
So
numbers
for-
were also given.
Numbers
So
are
the
also
last,
given.
now, my lords, they have accepted to take the saleage for those 5 sites also, which has been an alternate site. Now, lordship may kindly grant us a few days' time. We'll complete the execution of the sale deed. So that, my lord, we can report compliance.
When shall we give?
Any date, my lord. So a week later, my lords, any date.
A week later.
One submission, my lord, they shall not insist on the they are insisting for
Since the
alternate site charges 4,000 rupees because I am not at fault. Then that may not be charged. my lord.
pardon,
They are asking me to pay alternate site charges of 4,000 per site. Alternate site,
we'll see.
Let him take the sites. Without prejudice to his rights, let him take the sites.
only submit, I am not at fault for asking the alternate site. I suggested a site,
What they are asking, some charges.
some charges for giving alternate site.
4,000 rupees per site we are asking.
I am not at fault is my submission.
My lords,
It is
may
part of your,
may I suggest this, my lords?
part of your compliance.
May I suggest this, without prejudice to my learned friend's rights, my lords? Let him take the sites, my lords. Let him take the sites without prejudice to his rights, my lords.
To take the site, otherwise you will lose the,
Yes, my lords.
so
It's contempt, my lord. We are more anxious than the complainant, my lords.
it was stated by learned counsels for the parties jointly that the compliance of the order is being worked out in light of what is observed in paragraph, what is observed in paragraph, in order dated 5/2/25, full stop. The petitions have been next listed on when? 3rd March,
Please, my lords.
3rd March at 2:30.
Oblige, my lords.
So complete.
Yes, my lords.
You
we will
have, you have to
complete.
be practical in life. That's very important.
And take less fee of 4,000. Deduct from your fees.
Number 81. Srimati Shruti, second.
Number 326 in this matter. Respondent number 326, my lord.
What is it?
Commissioner
My
had,
lord had, by order dated 15/12/2022, directed the additional, the ADLR, my lord, to submit a report with regard to whether there were any constructions on a site which had been reserved for playground. The assistant director has not submitted the report, my lord.
Not submitted. The report of the assistant director, whom it was stated by learned additional government advocates, Srimati Akbar, is awaited. Stand over to 25th March. Obliged.
Obliged.
Case number 82. Shrimati Amrita.
For the including applicant.
My lord, the writ petition has become infructuous. My lord, we have removed the encroachment my lord, to an extent of 10 guntas. I have filed my statement of objections also.
Yes. Where is your compliance?
My lord, I filed it by way of a statement of objection. My lord will get it at paragraph 5.
Statement of objection.
Yes. Dated 6/8/2024.
Dated 6/6.
8/2024.
8/6, yes.
Five and 6, my lord.
Lordships, the encroachment has been cleared because of the order of the notice by this honorable court. And that has been cleared, but the humble submission of the petitioner is to replant the trees to safeguard the forest land and to fencing of the land. And that apart, your lordship may kindly see.
Replant the trees.
Yes, your lordship, because it's a forest land.
Trees
Otherwise,
were-
a re-encroachment.
Trees were uprooted.
Yes, your lordship is the. Which has been. And your lordship may kindly see in my petition, annexure L. Nearly about 850 cubic meters of soil has been removed. And it has been assessed as nearly 2,10,800 rupees worth by the encroacher. So he has to be penalized, your lordship.
I appear for the impleading applicant in this case. My lord. The impleading applicant, my lord, is a 67-year-old lady. She is disabled woman, my lord, who has locomotive disability up to the extent of 75%.
Uma.
My lord.
What is the name of the lady?
Umapati is.
No,
Lord,
no, no.
Umapati
His
is the
sister,
brother.
he's representing the sister, my lord. Umapati is the encroacher.
Umapati is the brother of the impleading applicant here in my lords. The premises that what she states is in front of the house of the brother, my lords. I am totally dependent upon my brother and I was.
Petition number 29296. 29296 of 2023.
And I have made an application to Tahsildar, my lords, to grant that land to me in the year 2018.
You are not necessary, you are disposing of the petition.
Property, my lords, was not a forest land and it is Kharab land. Could be seen in the RTC records filed in.
Filing this petition. In the nature of public interest litigation. The petitioner right to direct the respondent of the case to take action to remove the encroachment. Paragraph. The case pleaded paragraph was inter-alia that in Gere village in Shivamoga district. Survey number 16. Land survey number 16, at measuring 150 acres. Of minor forest. Was government land. Which was encroached upon to the extent of 10 gutas. It was stated that one Umapati, son of Yeshadraya, who had inherited the 10 gutas of land in survey number 2020. Occupied, he said, he occupied the occupied the 10 gutas by way of encroachment. And that he made ibex fencing and pillars. It is alleged that valuable and medicinal trees were also cut. He has also proceeded to cultivate the land from it was alleged. Petitioner, paragraph, who happens to be the farmer, further stated that he gave complaint to the respondents and also gave notices after registering the complaint. But the encroachment was continued. Full stop. Any of the state encroachment and inaction on part of the authorities. The petition came to the site. In response to notice, statement of objects has been filed by respondent. Filed on behalf of respondents. wherein it is inter-alia pointed out that there existed a dispute amongst the family members of Umapati. Full stop. Information in this regard was received from the forest officer on 16/2/21, wherein it was conveyed that the said Umapati had encroached upon the land to the extent of 10 guntas, which was district forest land. It was the information available with the forest range officer that the trees were illegally cut. And the wood was stored for firewood purposes. It was stated that range forest officer, deputy range forest officer was asked to inspect and give report. FIR was filed and a forest case was also registered under section 33(2) small v, small 5 and section 33(3) of the Karnataka Forest Act 1969 in view of the report. The deponent has produced copy of the FIR paragraph. It is further pointed out in the statement of as in the, it is further stated in this statement of as under extracting the relevant part from paragraph 5. So bracketed portion paragraph 5. Since the said guntas in so and so part of the district forest. About the inquiry conducted and the statement of the Umapati, following averments were made in paragraph 6. Then quote an inquiry set. With unauthorized occupation. Then further, it is further stated that since the said Umapati accepted the commission of offence and pleaded guilty, penalty amount was recovered under section 33(3) of the Karnataka Forest Act, read with the relevant rules. It was further stated that the range forest officer and the revenue officials initiated eviction proceedings and recovered the land to the extent of 10 guntas, which was encroached upon. It was pointed out that Mazar was also conducted on 16/7/2024 in the presence of the president of the Gram Panchayat, from a revenue inspector, from a beat forester, from a deputy range forest officer, from a village administrative officer. And after drawing the Panchinama, from a possession of the said 10 guntas has been taken. It was next stated paragraph that the officers were vigilant. Therefore, joint inspection was once again conducted. And it was ensured that there was no recurrence of encroachment at the site. The inspection revealed, from it was stated, from that there was no encroachment. And that the barbed fence struck by said Umapati was also removed. In view of the above, it could not be disputed by the petitioner as well that the encroachment has been removed. The proceedings of public interest petition are required to be closed. However, at this stage, learned advocate for the petitioner, Ms. So and so requested the court that since the land was forest land and the trees were cut, the status of forest land shall be maintained and the trees should be grown. Full stop. It is expected that the authorities shall ensure that the encroached area is grown with trees and the forestry status is reclaimed for the land. Petition is liable to be disposed of accordingly.
Your Lordship, he had unearthed some soil from he has excavated of nearly 850 meters of soil from the land. And he has commercially, he has used it. For that, some penal, yes.
They will take action.
Yeah.
My lord, pleading applicant is, my lord, sister of the encroacher, they claim to be. But the land was, my lords, encroached by the sister herself for cultivating the vegetables, my lords, and there were no trees to uproot.
My lord, that I have stated in my statement of objection that there is a circular and it cannot be regularized.
And the
Application
sister of
cannot be
the
considered.
claimed encroacher, my lords, had also made an application for the concerned authorities to grant, and that was not answered. My lord.
Nobody knows that the order is over.
It cannot be regularized.
Nobody knows that the order is over.
Yes, my lords.
You don't know the order is over. Order is over, you don't know. Then where is the question of any further submission? That's all. Yes.
Mr. 83, Mr. Mahendra, yes.
My lord, if a time or some time is given, my lord, we will consider the representation. Dated 18/10/2024.
Shall we dispose it of?
Yes, yes, I have instructions to say that.
Grievance was recorded. The grievance raised in the petition was recorded in the last order dated 4/2/5. Then quote the indicated part of the order. 8/9. Today, when the petition came up for consideration, learned additional law and advocacy law for stated that here the instructions in the subject matter and that the case of the petitioners,
Representation of the petition.
it is made
Yes, my lord, 18/10/2024.
representation of petitioner, which is already made on 18/10/2024, shall be considered in proper light.
My lord?
In proper light
Yes.
for the purpose of execution of lease deed. Yes. An appropriate decision in accordance with law shall be taken. Full stop. Learned advocate Mr. Mahendra for the petitioner submitted that the competent authority may be directed to take a decision within stipulated time. Full stop. The request is reasonable. The decision pursuant to the representation of petitioner will be taken within a period of 4 weeks. 4 weeks from the date of receipt of the copy of the order.
There is already a notification.
What?
Notification granting lease. Now only remaining is they have to execute lease deed. That's it.
Within
2 weeks.
decision dispose of accordingly.
God bless.
Obliged.
Number 30,
I appear for the petitioner.
Yes.
Last occasion notice was issued, date.
My lord, this order, my lord, the revision is available under section 53(1). Since it is an order or passed by the senior geologist.
This order is passed in pursuance of the order passed by the revisional authorities.
Very well, then I'll file my objections, my lord.
I think the papers are not right. Already time has been granted to the state law to file. A detailed order has been passed by the competent authority, narrating in detail, my lord. In fact, it is in favor of the petitioner himself. In pursuance of the amendment to Karnataka Minor Mineral Concession Rules in the year 2023, the competent authority has processed the application of the petitioner. The entire exercise was complete. Only at the stage of execution of quarry deed, they sought opinion from the legal department as to whether an alternative land can be granted to the petition. Now, at that stage, Lord, the competent authority, Lord, rejects my application on the ground that it has to be decided before the High Court. In the order itself, he says, Lord, that there are several instances of granting alternative land. Since it is a mistake committed by the department itself in granting the quarry lease area applied for by the petitioner to some other person when the application is pending consideration.
Now, ground is very peculiar. It appears that alternative site was requested by.
Yes, that was processed also.
And the legal department said that such course is not permissible. So therefore you rejected it.
Yes. My lord, I'll have a word with the officers.
You can reject on merit, but not on the ground that.
Yes, they couldn't have a word this.
Or you say that this second alternative sketch is not permissible under some rules.
They cannot say, Lord, because they only permitted to.
Permitted you to.
Yes, Lord, file, because they have granted 1 acre of my applied area to some other person. That is their first mistake. Thereafter, Lord, they sought for alternative sketch. I have produced it. They processed it in entirety. At the time of execution of quarry lease deed, they sought opinion from the legal department. And you'll ask me kindly see, under 16, Rule 16, it is not that it is totally prohibited. Under Rule 16, there is a provision. While extending the lease also, they can grant alternative land.
While extending.
While extending. This is a case of grant. Rule 16, subclass 3 proviso provides for that. In case in any judicial, quasi-judicial proceedings, the quarry lease is cancelled, then alternative land can be granted.
Yes, my lord may grant me some time.
Sure, that may be granted.
At the request of learned additional government, look for a court. Send over to 27th February will do.
Obliged.
Number 31.
Shall we list at 2:30?
My lord, I'll just make an attempt, my lord. If I cannot, then I'll leave it.
27.
31.
I appear for the appellant.
Yes.
This appeal is by the Lokayukta. Learned single judge, my lord, has struck down a rule, my lord, which has been in existence from past 40 years. That means where investigation is done by the Lokayukta, the rule says
So we can set down for final hearing.
But
We can set down for final hearing.
no, the point here is, my lord, nearly 100 such inquiries are pending. Now, all these inquiries, my lord, none of the inquiries can progress. So
what is that-
therefore, the rule, my lord, kindly see the rule.
Yes, what is that rule which is struck down?
Yes, kindly see page 37 is the rule.
47. 37.
Page 37, ink page 37.
It is quoted.
The rule 14A.
14A, yes.
May I read this 14A? No? The following provisions shall, notwithstanding anything contained in regulation 10 to 11A and 13 be applicable for purpose of proceeding against board employees whose alleged misconduct has been investigated into by Vigilance Commission, Lokayukta, Upalokayukta, either sumoto or on a reference from the board or from any other authority. Where on investigation into any allegation against a member of the board services, group A, B, C, or D, in respect of an allegation of a serious nature, Vigilance Commissioner, Lokayukta, or Upalokayukta, or any officer of the Vigilance Commission, Lokayukta, Upalokayukta, authorized by him in writing under Sub-Rule 2 and Rule 5 of Karnataka State Vigilance Commission Rules, Rule 12 of Karnataka Lokayukta, Upalokayukta Act is of the opinion that disciplinary proceedings shall be taken. He shall forward the record of investigation along with his recommendations to the board, and the board, after examining such records, may either direct an inquiry into the case by the Vigilance Commission, Lokayukta or Upalokayukta, or direct the appropriate disciplinary authority to take action in accordance with regulation number 12. Where the Vigilance Commission, Lokayukta, Upalokayukta, or any officer of the Vigilance, the inquiry may be conducted either by the Vigilance Commissioner, Lokayukta, Upalokayukta, or by an officer of the Vigilance Commission, Lokayukta, Upalokayukta, authorized by the Vigilance Commissioner, Lokayukta, Upalo, to conduct the inquiry, provided that the inquiry of a case relating to a board employee shall not be conducted by an officer lower in rank than that of such board employee. The Vigilance Commission, Lokayukta, Upalokayukta, or the officer authorized to conduct the inquiry under Clause B shall conduct the inquiry in accordance with the provisions of Sub-Regulation number 2 to 20 and Sub-Regulation 23 of Regulation 11 for purposes of such conducting inquiry shall have the powers of the disciplinary authority. Then, my lord, the court goes into the rule, deals with what happens after inquiry. Learned single judge holds that you have made a recommendation under the Lokayukta Act recommending that a disciplinary inquiry should be held. So, merely because you have made a recommendation, you cannot conduct disciplinary inquiry. That, my lord, in fact, there is not even a prayer in that writ petition. If your lordship kindly see the prayer in the writ petition at page 194, they filed an application or amendment. Amendment was allowed, amendment was not carried out at all. At page 194 is the prayer. What is challenged is the entrustment to the disciplinary authority, wide annexure H. What is challenged is only the entrustment. Later on, they made an application or amendment. Amended petition was not filed. Amendment was not carried out at all with regard to validity of the. But the learned single judge heard on this question of validity. But now the court holds that since you made a recommendation, there brings in the concept of inevitable bias. The question of bias does not arise. Initial recommendation, it is only a recommendation made by the Lokayukta to conduct disciplinary inquiry. There is no finding to that effect. And also the court says it is double jeopardy under Article 20. Kindly see, my lord, the reasoning given by the learned single judge with regard to double jeopardy at page at page 143. Page 143. A recommendation is by the Lokayukta. Inquiry is made by a district judge, either retired or sitting district judge. by two different officers. If your lordship sees page 143 at para 161, how does Article 22 would apply? It is only a recommendation to conduct disciplinary inquiry. He is not prosecuted or punished. At page 164 is the conclusion of the learned single judge. At page 164, at page 145. It is to be stated here that allowing Lokayukta police wing to prosecute the public servant and allowing administrative and inquiry wing to hold a departmental inquiry would essentially mean the boundaries that the law recognizes in respect of criminal proceeding and departmental proceeding stands eviscerated, would be manifestly illegal and arbitrary. There is no criminal proceedings here. What is done is a recommendation made under 12(3) of the Lokayukta Act. There is no criminal proceedings initiated. A recommendation, a complaint is received under section 9 of the Lokayukta Act. On that basis, a recommendation to conduct inquiry. Thereafter, government enters it back to the Lokayukta, they will conduct the inquiry. Now the learned judge holds that merely because you have given a report under 12(3), kindly see, my lord, the report under section 12(3) of the Act, you cannot hold a departmental inquiry by another officer, not by the same officer. Lokayukta gives a report that prima facie matter requires inquiry. On that basis, departmental inquiry is held. Learned judge holds, because you have made a recommendation, you cannot be Lokayukta officer that is headed by a district judge, cannot conduct an inquiry. That allegation, that pleading is also not there in that application or amendment. That plea itself is not taken. Your lordship may kindly see section 12, my lord, of the Lokayukta Act. Now, on this similar rule is there under the Karnataka CCA rules. On this basis, entrustment is made to conduct inquiry against public servant nearly more than 100 cases. And it is being done from past 30 to 40 years. Where is the question of bias, my lord, merely because a person makes a formative opinion to initiate proceedings? The learned judge says merely because you have made a recommendation, so you cannot hold inquiry.
Copy of the regulations.
What?
Copy of the regulations.
Regulation is extracted.
No, the whole set of.
Whole set. CCA rules. It is there in CCA rules also. Parimateria. That is the Karnataka Civil Services CCA rules. Rule 14A. Similar rules is there in the KPTCL, but both are similar. May I read below? Either direct inquiry ಅಂತಿದೆಯಲ್ಲ. The initial recommendation your lordship gets under section 12(3) of the Lokaयुक्त Act. Section 12, subclause 3. Section 12 of the Karnataka Lokaयुक्त Act. Subclause 3. If after what is relevant is subclause 3. 1 and 2 is different circumstance. If after investigation of any action involving an allegation has been made, Lokayukta and Upalokayukta is satisfied that such allegation is substantiated either wholly or partly, he shall by report in writing within 6 months from the date of commencement of the investigation, communicate his findings and recommendation along with relevant documents, material and other evidence to the competent authority. This is the nature of a recommendation. Recommendation is to conduct disciplinary inquiry.
And it is not binding.
But it is not binding on the government. Government can either do it or minor penalty they can impose and close the matter. They are only required to report. What is given is only a recommendation. Complaint is given under section 9 in relation to this allegation. If somebody makes a complaint, the authority looks into this and makes a recommendation. Now this recommendation, after this recommendation, government can entrust the investigation to Lokayukta, where either a retired or a sitting district judge will conduct an independent inquiry after issue of charge sheet.
What is the role of Rule 14A?
Rule 14A, my lord, comes into picture after this recommendation is given. Report is sent to the government.
After the recommendation given by whom?
Recommendation is by the Lokayukta.
Under 12.
Under 12(3). Section 12(3), he gives a recommendation. Recommendation will be to conduct disciplinary inquiry. In such a case, government can entrust the inquiry back to the Lokayukta, where inquiry will be done by some other officer who is of the rank of a district judge. And the learned single judge holds, merely because Lokayukta has earlier given report, the inquiry officer also will be presumably biased, and he will not be able to take independent view of the matter. That is not correct, my lord. Suppose any proceeding to be initiated, there should be prima facie material to initiate, not that they can go on initiating on every officer. So it is only in the nature of a prima facie recommendation. Pursuant to that recommendation, inquiry is done by a different officer. This is under this rule, every day inquiry is being held, my lord, from the past 30 to 40 years.
And even this particular, after it is entrusted to the district judge, that is additional registrar for inquiries, even their finding is again sent to the
government, disciplinary authority. Yes.
And again, before imposing penalty, the board will call for.
Correct.
And board can either accept it or reject it there also.
Reject it. Once again, that is also there, my lord. Rule 14A, kindly see. They will have to conduct it after inquiry, 14A subclause D. After inquiry is completed, record of the case along with findings and recommendations of the Lokayukta.
Tomorrow at 11.
What?
Tomorrow at 11. Let me go through. We can proceed for
Your Lordships, here notice is not yet served on the petitioners in the writ petition. I have been served with the copy by the appellant on the direction issued by your Lordships. I have informed the parties
Why learner single judge said that, then thereafter, the learner single judge strike down this rule? Then the inquiry is not possible now.
Inquiry is possible. The learned single judge in the order has stated that inquiry has to be conducted by the corporation.
No,
by
I appear for the corporation.
Corporation.
The difficulty now is that, my lord.
Not by local.
Not by Lokayukta.
Lokayukta,
Or
all
by the-
inquiries will come to
by-
a standstill.
by an,
because-
district judge appointed by the corporation. Now the corporation, in every cases, corporations have appointed district judge as inquiry officer. They have their own inquiry officers. In spite of that, since a recommendation is made by the Lokayukta, the corporation will hand over the inquiry to the Lokayukta without independent application of mind whether this is a suitable case to hand over the inquiry to the Lokayukta, or this inquiry can be conducted by our own inquiry officer. No such application of mind is there applied by the corporation in each and every matters. All those aspects have been considered, and also
according to
the other aspect is that your lordship,
on a single judge, the operation of Rule 14 capital A will automatically bring a kind of bias. That is what learner single
Yes,
judge.
yes, my
No,
lord.
if this
I appear for
if
the
rule is
corporation,
struck down,
and
my lord,
therefore, my lords, my respectful submission also before the single judge was this, my
corporation
lords,
has not preferred
that,
appeal.
my lords, there is no concept of institutional bias in our Indian jurisprudence, my lords. Personal bias, my lords, if an officer who has conducted criminal prosecution, inquiry, investigation,
Bring the appeal.
I have instructions to file appeal also, my lords, and I will be filing my appeal as
Their
well.
regulation has been struck down. They have
My
not
regulation has
they
been
have
struck
not
down.
preferred appeal.
Of course, I have my prerogative to right to seek my appeal is there. And therefore, my lords, that is my instructions. The concept of institutional bias does not exist here.
It doesn't exist.
It doesn't exist in our Indian jurisprudence. There is judgments, my lords, I will place and substantiate before my lords that, my lords, every judgment that the learned single judge has relied upon, the very same judgment is in my favor.
You are appearing for?
For petitioner in writ petition.
no petitioner, my lord.
Was there a prayer in the petition to?
No, I had amended the writ petition and I filed an application seeking for amendment, and that was allowed. And I had filed an amended
Amended
petition. I
Petition
had
was
filed
not
before
filed.
the.
This amendment petition is not produced.
No, that is not produced, but as I remember, your lordships, I had filed an amended petition also before
In
the.
fact, even that application or amendment, none of these grounds are taken. All these grounds are not there in the reading at all.
Petition also.
Your lordship,
Shows the amended petition.
no, now presently, briefs have been taken back, but
How do we
since
know that it
copies
is-
are served
How do we know that the amendment was allowed?
of
Either you show from the record of this court. We'll get the petition also.
because
In the-
as on today, I don't have file. They have taken back the brief, file parties. Since copy was served on me and my name is shown in the cause list, I have appeared. I have
But the
instructed-
difficulty is
I
this
have informed the
entire
parties
loci,
Can we not devote time for final hearing?
no, the difficulty is this,
From
the
tomorrow on-
loci, entire functioning, my lord, will come to a
Correct,
standstill.
from tomorrow onward, we start final hearing.
But I have no difficulty, I will argue the matter. What I would request is, my lord, you lordship may consider granting our interim order and simultaneously here, because all are more than 100 files are there, my lord.
We also,
But this similar rule is for the state government also. This is for KPTCL, that is Karnataka Power
By virtue of
Corporation.
the order of learner single judge, no inquiry is conducted.
But
everything is stalled, my lords, and inquiries which are still to be entrusted to Lokayuktas are all stalled. The only difficulty is, my lords,
enquiry ಬೇಕಾದ್ರೆ ಹೋಗ್ಲಿ ಬೇಕಾದ್ರೆ ನಮ್ಗೆ ರೂಲ್ ಸ್ಟೇ ಆಗುತ್ತೆ. All inquiries, my lord, against all government servants will come to a standstill because of this judgment. What I would request is, your Lordship may kindly consider staying of this, quashing of the rule. We are not concerned with this individual case. In fact, the inquiry wing of Lokayukta will become jobless. In
That
fact,
is
many
the-
district judges are
that's the-
posted there. Entire thing, nobody will do any work.
ನಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಸೈಟ್ ಅಷ್ಟೆಲ್ಲ ಇರ್ತಲ್ಲ ಇದೆಯಲ್ಲ. Now this tomorrow we'll take a car at 11. At 11 tomorrow.
Let that
Only
21
difficult
days
to-
delay is there, that may kindly be condoned.
Delay will come. Delay, having heard learned counsel of the parties, delay of 21 days is condoned. A sufficient cause is made out from the averments made in the accompanying affidavit explaining the passage of time. Application is accordingly allowed. Full stop. Writ petition may be listed, as requested by all the councils for the parties. Tomorrow on.
May I request
Is
you,
on which
Lordship,
date
since
tomorrow?
I have no
Yes.
instruction and since notice are not served on the parties, I may be handicapped.
Whose
in
notice?
appearing.
Notice is not served to whom?
Parties, I have informed out of service of these copies, I have informed the parties, but no instruction is given to me to appear in this case. So
That
I
for
will
us, it's
be,
a matter of great urgency, my lord.
Come
Because-
on, 19th.
if your lordship should permit me, if this, with regard to rule 14A, it may be stayed, and with regard to 211, the observation made in the,
So you are here, assisted the court, tomorrow you come.
no, my original file is not within me, so they have taken back.
But
the
on
file.
one hand, you are saying that you are not appearing. On the other hand,
He
you are
wants,
saying,
my lord, his
Because
enquiry.
if
on
they
the
are
other hand,
creating
you are saying
urgency
that the
and-
rule may be stayed. So it is more emphatic on your part. You are not appearing is more emphatic? Or your stand that rule may be stayed is more emphatic?
No, the reason,
We'll take-
the reason for making that statement is that, so without hearing that parties, if that portion is not stayed, they will not be affected.
What he
and
says
that
is
can
his
be-
enquiry need not be
You want
proceeded.
to
Rule
appear,
can
you
be-
are welcome to appear tomorrow. If you want to take instructions and formally appear, we can give time up to 17th.
The lordship can have it on 17th. So
17th.
that I will-
17th at 2:30.
Or I will inform them to make some alternative arrangement also if they are.
There is,
Lord, this rule may be stayed, the matter can be heard.
Then we'll consider. Let at least me understand the whole
Lord,
contours of the contract.
my lords, one request, my lords. It can be heard tomorrow itself and starting, my lords.
Lordship,
Let them
I have
take
it tomorrow.
instructions meanwhile. We are ready, my lords, because there's urgency because every inquiry is kept pending now.
You should have filed the appeal.
Yes.
No,
Yes.
you should have done it.
Yes.
Not,
Yes, my lords. Therefore, my request, my lords, only request, subject to my lords.
Why that much urgency? 17th, not far out.
Everything is in a standstill. as of
No,
now.
that, therefore
Lord,
17th. We are
if
giving
possible during,
We are giving priority to this matter, 17th. at
Lord,
2:30.
this week or on 18th, my lord.
18th. You give me for reading.
Lord, can it be 18th at 2:30?
2:30. Application IA for early hearing is disposed of since the matter is being posted, is ordered to be posted on 18th of February. 32 same.
Same.
So to
Same
this-
order.
Same order.
Different,
Different IS same. Order.
delay also,
Delay also, how many days delay?
19 days.
19 days. So order करके.
Yes. 33 ಅರ್ಜನ ಇದೆಯಲ್ಲ 33. 33 is urgent, still number 34.
My lord, sir, I am the
Ramesh Nayak, L, 14%.
and the
For
petition,
respondent number 3, my lord.
my lord, sir, this petition is about protection of lakes, my lords. There are two prayers in this petition. One is for the protection and preservation of one particular lake, Maidala Lake in Tumkur city, which proceeded for decades to Tumkur city. Second prayer is against the respondent number 4, my lords, to have the complete list of all the lakes in the state. After notice, my lords, R4 is not in existence presently, my lords. Your lordships on 17/12/24 directed me to give a process again. Otherwise, this petition stands dismissed without reference to the court. The thing is, my lord, so hence this IA, my lords, IA praying for recall and amendment of cost title, my lords. The respondent number 4, who is presently not there, my lords, the law which provided for establishment of the respondent number 4 is been repealed, my lord. In its place, in that place, Tank Conservation Act has come into force. So, respondent number 4 is not there, my lord. So, I have made a proposed respondent number 4, Tank. In its place, Lake Conservation and Development Authority. In its place, Tank Conservation.
Notice is not wrong.
Respondent number 4 is not in existence now, my lord, sir. The law provided for establishment of respondent number 4 has been repealed, my lord. In its place, the functions hitherto carried on by respondent number 4 has been transferred to Tanks Conservation and Development Authority, my lord. That's why I made a Tanks Conservation and Development Authority as a proposed respondent number 4, my lord. Notice may be altered to that.
So what do you want? You are serving number 4?
Yes, my lord, sir. The proposed. The present respondent number 4 of the petition is not in existence presently, my lord. The law provided.
Now listen, IA number 2 of 24. This IA is filed for recalling the order. The petition was dismissed on the ground that Disciplinary 4 was not served. Full stop. Disciplinary 4 is a Karnataka Lake Conservation and Development Authority. In course of the hearing of the present application, it was submitted on behalf of the council submitted by learned petitioners that this number 4 is no more in existence and no such authority exists. In that view, the order of dismissal of the petition is recalled. Full stop.
The proposed respondent number 4, my lords, Tank Conservation and Authority. I may be permitted to amend the cost title and notice may be ordered to that, my lords. All these functions of Lake Conservation Authority has been transferred to Tank Conservation Authority, my lord. And maybe I will give a process to R4 and I may be permitted to amend the cost.
Other IA is listed? No, not listed. That IA is not listed, Mr. Council. Get it listed and we'll pass the order.
Great.
Number 35, so Bal Gangadhar GS.
Who appear? Who appear?
Mr. Balgangadhar GS.
Complaints, my lord. Not comply the orders, my lord. Respondent accused number 3 and 4, my lord.
Your Lordship, I'm for accusation 3 and 4. The board is yet to be constituted, Your Lordship, and moreover, review petition was filed before this Honorable Court, challenging which SLP is pending before the Honorable Supreme Court, Your Lordship. That reason, the compliance affidavit is not been filed yet, Your Lordship. Your Lordship may grant 4 weeks time, file a compliance affidavit.
SLP already dismissed, my lord.
But I am only for 1 and 2.
Please dismiss.
SLP challenging writ appeal was dismissed, Your Lordship. Challenging writ review petition is still pending, Your Lordship. Still pending for consideration.
Can I make a submission? Lord? Since now they are the ones who have to comply. R1 and, accused 1 and 2 can be.
Your Lordship, onus is on the board to comply the order, Your Lordship.
He simply stated that the SLP is pending and that let the present contempt petition wait to be next posted on 7th April.
Please.
Since contemptor also says they are responsible, they have to do, and therefore I thought why A and 2?
This is only about some probation to be.
Payment of some, they've agreed to pay in the previous contempt. They will only do. It's just that we have to be accused,
to be paid?
may not be fair, that's all.
It is granting of some probation benefit retrospect.
But probation needed to be
That is how.
regularized, which they will do. There was one more contempt earlier, they wanted.
That only we gave a long date, not because SLP. SLP is only.
So I thought 1 and 2 can be deleted if my lords were to consider. 1 and 2 can be deleted.
Lordship
will delete.
Very well. I'll come back. Obliged.
much.
Section 37 connected.
37 is a similar matter. 37, it is a similar matter.
Same.
Please, sir, follow.
Number 38. Sigadi.
The complainants are the employees of the second respondent, Tank Conservation Authority, which was earlier a society. Well, they have been working for the last several years on contract basis, they were not regularized, and they approached this honorable court in a writ petition by invoking several judgments on the subject.
Appeal is filed, my lords, and is posted on 5th of March, my lords.
Writ appeal has been filed with more than 300 days delay after the notice in this contempt petition has been sent. And I have filed my reply also to the delay condonation application. Perhaps absolutely no reason in that application for condonation delay. Here what happens is that, my lord, they are not considering I'm implementing the Honorable Single Judge's order direction. 2 of them have retired attending the superannuation. 1 of them has moved to the Government of India service. Like that, my lord, they are suffering, and they are not taking steps even to expedite the hearing also. Writ appeal I have seen, and absolutely, my lord, if that reason for condonation of delay is seen, there will be no case in the registry without condonation of delay. That much bad. Maybe tomorrow or day after, if the writ appeal is listed along with this, I have no difficulty. They are suffering, my lord, without that's every day there's a threat of termination.
As the writ appeal filed in respect of the order, judgment and order, this subject matter of this contempt petition, is to come up on 5th of March. These contempt petitions have been listed along with
Appeal number 1550 of
133
1500 of 20.
1500.
2020.
We have filed our reply in that. Please.
So for the respondents, I seek time to file a reply, my lord, in this case.
They are not complied, my lord. Appearing for complaint. Appearing for complaint, my lord. They are not complied. Appearing for complaint, my lord. They are not complied.
I pressed time to file a report regarding we have complied the single judge order, my lord. And regarding reinstatement, we have passed order on 1/8/2024. It was communicated to reinstate the petitioner, my lord. In spite of that, she has not reported to duty. In this regard, I will file my reply. Kindly grant some time. There was an order to reinstatement to conduct inquiry, my lord. We have reinstated by the order dated 1/8/2024. It was communicated in writing, my lord.
Inquiry is initiated, press inquiry.
We will conduct inquiry, my lord. Not yet conducted, but we have reinstated her.
Reinstated.
Reinstated on 1/8/2024. But she is not ready to report duty. In
Yes.
spite of service of notice.
My lord, on short act, and have it on next week, my lord. I will take instruction.
No, why should you take instruction? You tell that you will report for duty. They are ready to reinstate. The present contempt petition is in respect of non-compliance of direction whereby respondent society is directed to reinstate the petition with consequential benefits. Full stop. When the petition comes up for consideration, a reverse situation than normal is obtained. Inasmuch as respondent, inasmuch as learned of the respondent has stated that the respondent is ready to reinstate the petitioner, however, the petitioner is not responding, is not reporting.
On 1/8/2024, you have survey notice. On 1/8/2024.
That on 1/8/2024, notice was already sent the
Sir.
petition to report for duty. Full stop. When you are report for duty?
Kindly short accommodation, my lord. Have it on next.
No, you report when you are going to report for duty. Dismiss the petition. If you are not going, then where is the question of their committing contempt?
I will take instruction, my lord. Kindly have it
What
on.
instruction? What instruction? Tomorrow?
Oh, yes, ma'am.
Tomorrow?
Yes, ma'am.
Tomorrow at 2:30. And what about the benefits?
Benefits, my lord, she was a temporary employee. Subsequently, she has not reported
Whatever
duty, no
benefit
salary.
You have to pay, you have to comply with.
My lord, I will file a reply in writing and translate a copy.
I'll reply.
Grant some time, reserve time.
Kindly
File a
tomorrow.
reply in writing, my lord.
No, you are saying that you are going to reinstate. Let that part be complied with
Yes.
tomorrow.
Yes.
Tomorrow 2:30.
41 are urgent, number 42. Direction issued by this honorable court. Page 22 minute, starts at 18.
My lord, please for your accommodation, my lords. Necessary steps have been taken to file a writ appeal, my lords. The prayer of the accused respondent in the petition was rejected, my lords, with regard to the non-availability of the funds to release in favor of the complainant, my lords.
My lord, the work was completed, bill was certified.
Amount towards what?
My lord, for executing the work, my lord, the work was completed, my lord, they have not made the payment. They took up the content before learned single judge, my lord, that they do not have the money, they will pay on priority basis. My lord, in case clause 37 provides, my lord, within 60 days, they were required to make the payment. My lord, the learned single judge, my lord, in view of the decision taken, directed them to release within 4 weeks, my lord.
Yes.
Now, 3 times adjournment
My
taken, my
lords,
lord.
necessary directions have been issued to file a writ appeal, my lords. Writ appeal will be filed, my lords.
You deposit.
Because in the specific contention, even before the learned single judge, my lord, that there are other contractors who are supposed to be paid, my lords, and some funds were not available, my lords, at that point of time, my lords. For such reasons, Lordship may kindly see for a moment paragraph 4 of the order of the learned single judge, my lords. That a specific contention was made that on basis of priority, his amount will be cleared, my lords. The said contention was rejected by the learned single judge, my lords, and passed an order that a sum of rupees 919 lakh has to be given within period of 4 weeks, my lords. Since the amount is huge, my lords, same time they are filing a writ appeal in this matter, my lords. They were short accommodation, my lords, and will update on the matter. My lords.
29/10/2024, lordship granted time, my lord, almost 4 months. 3.5 months. Work is completed. They have issued completion certificate. Clause 37 state, my lord, within 60 days, they have to make the payment, my lord. Please see class para 21, my lord, the learned single judge has extracted, my lord. These funds are made available, my lord, in the budget. They are available, my lord. If they have not paid the money,
Raghavendra, when you are going to pay? This will not, filing of appeal will no ground.
Yeah, and I understand, my lord.
This 919.10 lakhs.
If a short accommodation is granted, my lords, I'll come back with the positive result, my lords.
9 crores.
On 26th June, my lords, order was passed. Short accommodation is going, my lords, come with a positive result, my lords.
Appeal is filed,
Appeal will be filed in this week, my lord.
not filed.
Steps have been taken.
After notice, you are to moving yourself.
If a short accommodation, my lords, I will,
Take instructions on
Please.
20th.
please.
Show something concrete by 20th, so we can consider.
Please.
Otherwise, we are compelled to file some. You understand what we are suggesting? Yes.
Please.
21st of.
Please.
Yes. Everywhere.
Still number 43, Mr. Sachin BS.
My lords, the complainants are employees belonging to A-grade temple, my lords. As per writ petition order, my lords, in page number 66, my lords, single judge had ordered for implementation of sixth pay commission, my lords, from 1/4/2018, my lords, as given to other A-grade temples. But it has not been complied, my lords. And they have filed a writ appeal, my lords,
It's coming up,
1784 of 2024.
the day after tomorrow, my lord. 14th is coming up, lordships, my lord. Day after
Lords, it
tomorrow.
is listed for non-compliance of office objection for 9th time. They have not complied the office objection.
Appeal number
No, it's clear, my lord. It's coming up on
1784 of 2024.
178 of 2020.
24.
Number 44, to P N Harish.
The accused.
Reply, my lord, and come on.
Lordships, we have complied.
Reply has to be filed.
Reply has to be filed, my lords. We have complied with the order and we've given them the temporary electricity connection as well as entered their name into the property register. That was what was directed by the single judge, and we'll file the.
They not received the copy, my lord.
Yeah, we'll file it.
They'll take instruction with a short accommodation, whether it is will come. What?
18th of
Please.
February at 2:30. Since according to learned review of the respondent, the order is complied with and the electricity connection is applied. Is given.
NOC has been given.
Full stop. Take
Check,
instruction.
please.
Number 45,
45 for the complaint, my lord.
Shekhar.
Lord, Honorable single judge ordered to consider my representation and pay the compensation amount, my lord. They are not yet for compensation amount for having acquired the land, my lord. The order is at page number 11, my lord.
Here, towards you.
KADB would appear, council would appear. Government is not a party.
KADB, my lord.
Industrial area development.
25th.
Obliged, my lord.
Yes, next.
Number 47, to Devarajan.
But the order of penalty, my lords, has been modified, my lords, by the learned single judge as per Annexure G. Page 62 is the operative portion, my lords. 4 increments with cumulative effect has been modified to 2 increments without cumulative effect, my lords.
So you are entitled to the monetary benefit.
Yes, my lord.
Benefit, that kindly, my lord, the 2 weeks I will report it so far as that after compliance of the monetary benefits.
Learn a single judge while disposing of the writ petition. Penalty of, so substituted the penalty of withholding of 4 increments with cumulative effect. with one penalty. With the penalty of two increments without cumulative. This will entitle the petitioner to some monetary benefit due to modification of the penalty. Learned advocate Mr. Swansea, 6 times. 2 week time is granted. However, within 2 weeks, the order shall be complied with, failing which the court will have to take a serious step. 10 over to 12th March.
Watchable.
How many meters?
Says 48 is urgent, number 49. Mr. G.S. Srikantegowda for petitioner's letter. Memo is filed to delete accused number 3271. Memo is filed to delete accused number 3271. Lord, on 14/6/2024, we have filed memo to delete accused number 3271. There was no direction against them.
What is not able to understand anything.
Office has raised objection regarding making of 40 respondent number 125, my lord. We have filed memo to delete
Delete the respondent. All right.
327.
Learner said that he has filed memo for delete respondent number.
Accused number 327.
Respondent 327.
Yes, my lord.
They stand deleted at the cost and consequences of the applicant. Full stop. The memo shall remain on record. Next.
Number 50. PC Vinita.
For complainant, Lordship, they have done the partial compliance. In fact, they, as far as the bund is across the river stream, that has been removed. But insofar as the road formed by removing the fire fencing, that they have not complied. Even though I have produced I filed my rejoinder, Lordships, that is on wherein I have produced the documents also. On 15th July 2024, I produced I filed my rejoinder. Along with that, the sketch and the commissioner's report, wherein it is clearly, they have admittedly, they have agreed that there is an encroachment of the land by removing the fire fence, which was put up by the complainant. And in fact, the order, Your Lordship, that they have disobeyed, where partial compliance is done, where my request has to be considered with respect to both the prayers. So far as the removal of the bund is concerned, they have done. But the road that formed the private road.
Doubt what is going.
Please, my lords. For a moment, my lords, para 6 of my complaints affidavit, my lords. Para 6 of my complaints affidavit, my lords. For a moment, page 3 of my complaints affidavit dated 23rd April 2024, my lords. As specifically stated, my lord, joint survey was done, my lords. At that point of time, no such objection was also raised by the complainant.
Bond constructed in a small
I have para 6, my lord, I humbly submit the joint survey was done on 4/4/2024 by Forest Revenue Department and the Assistant Director of Land Records, Virajpet, and submitted survey sketch report on 2nd April 2020 stating that the bund constructed on a small stream flowing between the forest boundary in so and so belongs to Forest Department.
But
And
her
that the
grievance
necessary-
is different. What is your grievance?
My grievance two grievance, your lordship. One is that bund which is across the stream. The other one is private road formed in the forest land with damaging my fire fence, which has been put up by the complainant. I, in fact, along with my rejoinder, your lordship, I produced Annexure E, the commissioner report, what they have stated in paragraph number 6. It's not correct. To substantiate that, I have produced the Annexure E commissioner report, where they have admitted that there is a report that's saying that she has encroached the forest land and they have put up private road. That is the grievance, your lordship.
My lords, if lordship sees the order passed by the learned single judge, my lords, a representative was to be considered within 3 weeks, my lord. And accordingly, my lords, the
Very
The-
true, your lordship. Only submission I would, if your lordship could permit
within
me,
3 weeks from
the
date of receipt. This
complainant
consideration is considered, my lords, and based on which joint surveys are also
Considered
done.
now.
not considered.
You considered.
Please, my lords.
Where is the order?
Annexure R6, my lords. Para-
R6.
Please, my lords, page number. The translation copy is at page number 26, my lords. It is an endorsement dated, my lords. On 5th April 2024, endorsement has been issued, my lords.
That is only with respect to one of the grievance.
The last paragraph translated part, page 27, my lords. Based on the service case, Srimati Kotaganda Viju Devaya Verukoli Estate has been issued a notice in reference 7. It is directed to remove the bund constructed by her on the natural stream which is in the forest land, and any other construction done by her in forest land within 7 days with receipt of the notice of her own cost. If failed to do so, the Forest Department shall lodge forest encroachment case and take legal action as per the Karnataka Forest Act 1973 and Wildlife Act. This post-description is given for a complaint. file.
That is only with respect to the stream.
You have put the onus on the other person to remove the encroachment. You have not removed the encroachment. That's what your letter says.
May I read the Kannada version, my lords?
Both Kannada and English, it's a proper translation only. See, even if you read Kannada version, it says the same thing.
ಮುಂದುವರಿದು. ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 7ರ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಸರ್ಕಾರಿ ಅರಣ್ಯ ಭೂಮಿಯಲ್ಲಿ ಆವರಿಸಿದ ನಿರ್ಮಾಣಿಸಲಾದ ತೊಡಿಗದ ಕಟ್ಟೆ ಮತ್ತು ಇತ್ಯಾದಿಗಳ ನೋಟಿಸ್ ಸ್ವೀಕರಿಸಿ 7 ದಿನಗಳವರೆಗೂ ಖುದ್ದು ತಮ್ಮ ಸ್ವಂತ ಖರ್ಚಿನಲ್ಲಿ ತೆರವುಗೊಳಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ.
See, her grievance is forest land has been encroached by private persons. You have not taken any action to remove it. And as prayed by her, writ petition has been allowed. You have been directed to initiate action in accordance with law by considering it representation. What you have said, you have issued notice to third party to remove the encroachment within a period of 7 days. Failing which you will initiate necessary action. That is not compliance.
I seek necessary instructions and I'll come back, my lords. On this, my lords, what has happened subsequent to 5/4/2024, what has been happened,
What is happened?
my lords? On 5/4/2024.
We did not see what is happening. We have seen from your stand what is happening.
No, on 5/4/2024, this endorsement has been issued, my lords. Subsequent developments, I'm get to take instant
That
because
endorsement itself is non-compliant. Because you are passing the buck.
Lordship, so one more grievance is that, your lordship, they, as for the stream, they have issued notice. And what is more, damaging me, it is that private road which they have encroaching the
18.
forest land, which fire fence, which is they have embalmed fire fence, that has been, she has removed that fire fence. So now I have been affected with these wild animals and all this, since it is a part of Nagrahole Wild Sanctuary. Very clearly, specifically, I have mentioned in my representation regarding the encroachment.
The bund has come up on that fire fence, is it?
Bund has come up on the across the stream. There's a stream.
Okay,
She
across
has
the stream.
completely encroached the forest land. She has formed a private road, and even she has put up a bund across the stream and blocking that where she could dump the mud from making this private road. The only thing is that all the forest officials and everybody, they have been knocking the door from past 6-7 years. The only thing being the private person here being an IAS officer. So that is where this is not happening, to be honestly.
G3 is the road. Actually, G3
Yes,
is the road.
yes, please. I produce the materials. From G1, it could be seen she has totally removed the fire fencing. And G3, the private road which she has formed, encroaching this forest land.
Fire fencing is what they will dig.
Correct.
So that it won't,
yes, they dig it, and the fence will be where the power, electric power will be given on the fence. Only to stop the wild animals. The pillars will be erected and the pillars will be erected and the fence will be with the electric power will be.
Come on, 18.
Please, my lords.
18 per 2.
Number 51 to Shailesh.
Appearing for the complaint, my lord. After filing of complaint, my lord, A1 is transferred from Karwar to Mumbai, my lord. I given fresh address by taking steps, my lord. Office raised the objection that non-filing of memo of substitute service, my lord. Therefore, a memo is ready, my lord. I will file in the office. Kindly issue notice to A1, my lord.
Notice.
Please.
Notice.
I appear for the R2, my lord, respondent number 2. I undertake to file wakalat on behalf of R1 and R3 also.
Please. I'll before 7th March.
Great.
Number 52.
For the complainant, in this case, my lord.
52 is over. 50. Over. Wrongly done. 53.
52, my lords, I'm appearing for the complainant. My lords, in the last occasion, notice was issued to the accused 1 and 2. They have not filed their complaints affidavit, my lords. The crux of the matter is this, my lords, the complainant company's land was acquired by the accused number 1. Compensation was not paid. Learned single judge, my lords, wide order dated 11th April 2014, my lords, directed to pay the compensation amount. It was not paid, so my lords. Thereafter, I filed a contempt petition. This is the second round of contempt proceedings, my lords. I am before your lordships. My lords, in the first round of contempt proceedings, my lords, the accused had undertaken to comply the order of the learned single judge within 4 weeks. They failed to do so, my lords. Now I have again filed a contempt proceedings, my lords. Notice is issued. They have not filed the complaints report also, my lords.
Who will appear? State. Not south. This one number one is not sought.
Notice is still not, service is not complete on this.
You are also liable. Your officer.
Accused number 1 is Special Land Acquisition Officer, my lords.
Learned additional government advocate, Mr. Raghavendra, is directed to accept notice on behalf of the only respondent. No, not on behalf of respondent 1 as respondent 2 and 1. Respondent 2, State of Karnataka, and respondent 1, the Special Land Acquisition Officer, who is also an officer of the state. Instructions will be taken before the next day regarding compliance of the order. Stand over to 12th March.
Much obliged.
Number 53. Mr. Ashok.
53, I am appearing for respondent number 5, my lord. My lord, this petition has to be dismissed with exemplary cast, my lord, for wasting the judicial time, my lord. The order passed is at page number 58, my lord, that has been complied. My lord, the facts are this, my lord. The petitioner was in the first round selected by the Karnataka Examination Authority. It was cancelled because he has not submitted some documents. Then in the second round, a seat was given to me. I continued the studies, my lord, for 2.5 years. After that, this Honorable Court passed an order, cancel my admission and give admission to him. That has been done, my lord. Fortunately for me, at that time, there was another vacancy arose. Therefore, the National Medical Council has given an opinion at page number 107, my lord, 107, and given an opinion that
A week's time may be granted. A week's time may be granted. A week's time may be granted to submit my
that the
arguments.
case can be dismissed today
A
itself.
week's time may be granted to submit my arguments, Your Lordship.
All right, you will not may give time, but today you will not may kindly hear this, my lord. Para 5 of page number 107. Kindly see, my lord. Kindly see, my lord. What happened, my lord? Another seat became vacant, which was allotted to me after obtaining an opinion of the National Medical Commission. That order is challenged before this Honorable Court. That petition has been rejected. This contempt does not survive for consideration, my lord. Kindly see page number 107, my lord.
You are appearing for
I am compliant, Your Lordship.
complaint.
For the respondent number 5, I filed the objection yesterday. My lord, kindly look into one paragraph, my lord, then your last may kindly see. Page 1.
I undertake to appear. Yesterday we were served as far as NMC is concerned. I undertake to appear for respondent number 3.
But who will
My
be
lord, page number 107 at para 5, your last may kindly have it. Entire matter will be.
to be listed on 7th April. Next.
Much obliged.
Number 54. Murthy K.
Await notice. Respondent number 4 to 6 is awaited.
Pardon.
Appear for the appellant, man.
Little loud.
As well. Appear for the appellant, man.
So what do you want?
Notice was awaited in respondent number 4 to 6.
Notice is awaited. What is it? Not interested in conducting, then we'll adjourn it. Notice to respond 4 and respond 6 is yet to be served. In that view, let the service of case is awaited. The appeal may be posted thereafter. On thereafter, date given, date 7th April.
Number 55. Mr. Ravin Kipanna.
I am for the appellant, my lord. My lord, in this case, the appellant who was working as a driver come.
Delay is condoned or not?
delay of 32 days, my lord.
Condon,
Yes, it may be condoned because
Cabinet Council, what is delay of 32 days is condoned as sufficient cause from the advertisement in the accompanying affidavit. Application is allowed accordingly. Writ petition may be listed for
one submission, my lord.
admission hearing on 20th March.
One submission, my lord. Because he could not attend the driving work, disciplinary action being initiated. It is going on during the pendency of this appeal. They want to conclude the disciplinary inquiry, and he may be likely to be terminated from service. Let the other side to maintain the status quo at least.
On that day will hear matter. We keep it early.
Please.
27th of February.
Please.
Number 56, Vidulata.
My lords, I appear for the appellants. We had filed 2 memos for dispensation of notice to respondent number 1567 to 81. Now, my lord, with respect to respondents number 1 and 5, we have already paid the process fee on 23/12/2024. And with respect to notice on respondent number 6, it is the parent society which no longer exists since it is bifurcated into respondent number 5 and 4. So, and also with respect to respondent number 7 to 81, they were the petitioners in WP number 8 to 67 of 2015. They were the co-petitioners, and they are the formal parties and not the necessary parties. So this honorable court may be pleased to dispense the notices to be served upon the following respondents.
No, if there are parties in the writ petition, they have to be served.
My lord, I seek a short accommodation. My senior will address regarding this.
28th of February.
Much obliged.
So number 57. Mr. N. Shankar Narayan Bhatt.
These respondents have filed the application. The matter has been disposed of long back. Respondents have filed for modification the order, and on last occasion on 6/1, they said joint survey would be conducted. And they have to submit a report, BD and
Report is report is filed.
I'm not.
You are for the respondent.
I am for the appellant, my lord. Matter has been disposed of, and respondents have filed an application for him.
No, you are not in hurry. 8th of April.
8.
So number
Also PIL. Oh, then keep it earlier.
My lord, it's over. I'm filing compliance report. We have complied the order, so the petition will be disposed.
It's regarding the encroachment of about half an acre. They have cleared it.
We have cleared the encroachment.
You are for petition.
Petitioner, well.
58.
58.
58. All. What about 57? 57 will be kept on 3rd March.
So number 58. So Madhusudan Adiga.
Petitioner by me. Encroachment about 3/4 of an acre.
Lordship, appearing for respondent number 5, as per our survey report, we have carried out with the removal of the structures. Hence, the petition may be disposed.
Which rule?
Will take on.
Comply.
Yes, my lord.
Still number 59. Writ petition PL, Mr. Vinayak. Mr. Vinayak.
None is present, stand over to 3rd April.
Number 60.
For the petition of this matter, my lord. Respondent number 6 died, my lord. There is no cause against the respondent number 6, my lord. Delete the respondent number 6, my lord. Respondent number 6 is died, my lord.
Who died?
I filed the memo.
Number 6 is died.
Yes, my lord.
This one number 6.
Yes, my lord.
Take steps if you are interested.
PAL matter, my lord. There is no cause against the respondent number 6. Delete the respondent number 6, my lord.
Learned advocate for the 6th deletion of respondent 6. Full stop. Respondent 6 is deleted as requested from the area of respondents. Cost and consequences of the petition. Appel petitioner. Yes, what is it about?
PL matter. Short accommodation for hearing. Illegal mining and stone crushing caused by the respondent number 5 to 7, my lord.
March 27th.
I appear for the petitioner, my lord. This is a public interest litigation. My lord, this is a public interest litigation. The respondent number 9 is damaging the road, my lord. Therefore, we have made the application to the authorities to take action against the respondent number 9, and they have not done it. A public road, removing the public road. Photographs is also submitted and several representation earlier was also done, and the authorities was removed the obstructions earlier. The paper publication is also submitted. Annexure F is seeking writ of mandamus to take necessary action against the respondent number 9. Who damaging the road, public road. They have not even filed any objections, my lord, till to.
File reply.
My lord, I have filed wakalat. That has not been put up by the office. My lord, my name may be shown in the cause list in next time. I have filed wakalat.
Name of the.
For
counsel.
reply. For reply, I seek some time.
So name will be shown only if you file reply.
Correct?
Name of the counsel shall be indicated on board only if the counsel files reply.
Then I raise some time to reply.
To file reply is granted up to.
It is a personal interest, not public interest. Decree has been passed by the number of courts against the petitioners. They have suffered the decree. Now they are seeking as a public interest, they are filed this petition.
So all this sentence you write in.
Then I will reply.
Then you will file.
My lord, 2 weeks.
2 weeks. So stand up to 11th of March. Stand over to 3rd. Then stand over to 17th.
11th.
17th March. Don't write it. Not possible.
Lord, I thought both of us had submitted that we'll file written submissions with that it can be treated as closed. That was the joint submission that we had made. Between us, by Tuesday, both of us will file a very short synopsis each, capturing our submissions in brief, which your lordships can consider and pass on.
So we'll reserve the judge.
Yes.
Third learned. Solicitor General of India, Mr. Kamath for the appellant, assisted by.
Ms. Sarojini Muttannam.
Learned advocate, Mr. Senior advocate, Mr. Respondent at length. And counsel for the party stated that they argued the appeal. Finally, they further stated that the proceedings are over and no further are required to be added or supplemented. Full stop, paragraph, reserved for judge.
Lords, except filing of short synopsis.
By Tuesday.
Please.
Within 3-4 days.
By Tuesday. We'll hand over to the court officer.
Please.
It's heard and reserved.